There we go. All right, good morning. Okay, so I can only assume we're online, but I've actually talked to Terry about getting the camera, have the red light, so we know whether the camera is on or not. But, so hopefully no, there is no red light evidently. It's an extra. So hopefully we'll get that taken care of. Okay. What's our first wheel? Oh, this is, the fun one, right?
45.
All right. Okay. So we have an amendment in front of us, Keith,
Yeah,
and it's all of how many pages?
quite a few.
All right,
19.
19 pages.
And then we have this presentation that will explain section by section.
Okay. I think why don't we, I guess, the first question I have, is there anybody in the audience who is concerned or has problems or anything we need to know up front about 645? Okay, good. That's what I wanted to see. No,
I can introduce it.
no news is good news. All right, so, okay, so we have a presentation.
Yeah, and I have some opening remarks if you want.
Yeah, right.
Right. What's that, Representative
okay.
Spear? You couldn't hear me?
When you faced that way, I couldn't tell what you were saying. What are we going to be doing with 645?
We will hope we will be passing this amendment.
We're not going to talk about the new amendment
Yes.
first?
That's what we're going to do. We're going to
Okay.
have a presentation on what the new
But
amendment
we can't
says.
say
Okay.
whether we're gonna up
Well,
or down if we haven't heard it.
No, I was more worried about anybody in the audience who has had any concern with this bill at the moment, so that we knew ahead of time if there was going to be problems. But if
But
that,
they haven't seen the amendment.
but the amendment's been floated around, yeah, so, but we'll find
Well,
out.
They may not have
They may
seen
not
it.
have seen it,
Okay,
so they may object. if They've seen it.
that is true. Okay, all right, you're on, Keith.
Thank you, Mr. Chair. So I'll just give an opening high-level overview of what we're talking about here, because this is new territory for jurisdictions. This concept of a DAO utilizes technology to allow for collective action. Okay, so a lot of the concepts are very old. Governance, right? So the state itself is similar to a DAO, right? So people vote on their representatives, and then we sit on this committee and we vote on proposals. And those proposals are called bills, right? And our vote determines the outcome of that process. So what a DAO does is utilize technology to capture that in a form where it's cryptographically provable.
Crick, would you mind moving your mic closer? I'm having trouble hearing. Thank you.
How's that?
Thank you. Thank you.
Did you hear me so far?
Yeah, thank you.
So what kind of tools do you need? Well, if you know how to use a web browser and you know how to install a plugin, if you know what a plugin is for a web browser, you pretty much have all the tools you need to participate in a DAO. And some of the newer web browsers have this functionality built right into it. So it's not something very esoteric. It's becoming more easily usable. So what we could do if we wanted to, I could open my laptop. I could create a DAO, and it would, yeah, I could, right? And I could give each of us an ID, like an NFT. You probably heard the term NFT. We could all each have a way to prove who we are, and then we could submit proposals, which could be a bill or something like that. And then the system would track our votes and determine the outcome. And it's all open on a blockchain. It's all publicly viewable and auditable, and it's immutable. It can't, those votes can't be changed. So that's just to give you like a way to think about it. And so this amendment is an attempt to give a DAO legal personhood. So there's DAOs being created this minute all over the internet all the time. Some of those organizations, some of those collective actions may become the next Facebook, Google, Meta. They may become that big in the future. And so what this bill is trying to do, and other states are doing it, other states have done it, is give the ability for a DAO, a group of people acting collectively on the internet, a way to register with the state to have conferred upon it some of the same things that LLCs and corporations and other legal entities have. So why would the DAO want to do that? Number one, to limit their liability. So we have limited liability here when we make decisions. We're protected by the state, that we can't be sued for our votes, right? Does that make sense? So when you confer limited liability onto a corporation, we're franchising what we have onto that entity. That's basically what we're doing. And the reason why a DAO might want to do it, one, for limited liability, so that they can't be sued. They can only lose their investment, just like you do with an LLC. And then also to interface with the legal system. So DAOs can hire employees, and they can give those employees benefits. And there are other DAOs that those DAOs can interact with to provide those services. This ecosystem is being built right now on the internet. So that's, one reason is to interact with the legal system, have a bank account, own real property. And I invited someone to come, if we have time to have them speak. Kumar, if you could just raise your hand. Kumar can talk to us about how tokens can interact with real world assets. So that's tokenization of real world assets. That's a separate but related topic. But a DAO can do that. DAO can own a token that represents a real world asset. So what this amendment does, and we're going to walk through it, is it takes definitions from model law. There's a group called Koala, and they're lawyers all around the world working on this. That's what we started with. That's what we heard back in February. So then we've got input from other stakeholders, and we pulled in existing statutes, some of it from existing LLC law, to kind of round out, to kind of fit that model law into the current framework in New Hampshire. So it's a detailed subject, as you can see by the stack of this presentation, but it's very interesting, and we're kind of at the forefront of a new way for people to collectively act and also have some ownership over that action. So there's complaints about corporations that only a few people make the decisions, only a few people own the assets. What a DAO does is it allows lots of people to participate in those decisions and have a little piece of ownership. So it's an exciting topic.
So any questions so far?
No, it sounds like
You need to turn on, yeah.
sounds like he's talking about a union.
I'm sure a union could use it. Yes,
Yeah, you
I'm
could
sure.
create a union with a DAO.
Sorry, what was the question?
It sounds like he's trying to create a union. Or it sounds like a union.
A
A
union.
union.
Yes.
You could run a union.
I'm all
with
for
a DAO.
unions.
Yeah.
I do have a question.
Okay, yes. Anita's, I was going to recognize Anita next, so.
Okay.
yeah. Representative Brett.
Thanks. Representative, could you give us an example of a real life DAO that's operating right now, just to kind of give us a real life example?
Yeah, so DAOs can be used for a lot of things. So one of the first uses was something called decentralized finance. So you've probably heard of DeFi. That's a fairly new term. But a decentralized, a DeFi system would be a system that operates in computer code that people can use to trade one token for another. So like one token that represents an asset for another token. And, sort of like how the stock exchange works. So that's kind of an early example. But there's more recent examples where there's a DAO that is for the film industry. So they're crowdsourcing and crowdfunding the development of new movies, and they're selling advanced tickets to those movies. The ticket is an NFT, and when they make the movie, you can use the NFT to watch the movie or get special extra features. and that could replace Hollywood at some point, right? So there's, it's possible, right? So there's a DAO that is funding military equipment and food and resources for victims in the Ukraine. So there's something called the Ukraine DAO. So that'd be a philanthropy DAO. So there's many more examples happening. It's a experimentation, and the cream kind of rises to the top, right? So a lot of DAOs may not be successful, but eventually, the best ideas rise to the top.
Follow up? Can you give me one example of a scenario where it might be a DAO, I'm trying to phrase this, a DAO would be dangerous either to security or to an investor?
So define dangerous, right?
Be used to subsidize terrorists or that kind of thing, or somebody loses their money and don't have a secure investment, like Mr. Freed, who's going to jail for the rest of his life.
Yeah, so that wasn't a DAO.
Okay.
Actually, there's a point that if FTX had been a DAO and registered in a state, that would have provided more protections to the participants. So FTX is a centralized offshore system. It dealt with digital tokens, that's true, but it's not related.
Okay. So what about
Number
funding
one.
terrorists, for example?
With a DAO? I mean, if it was caught doing that, in the bill, the AG would eliminate their legal protections.
Okay.
So
I mean, then the idea is that now we actually have a structure in the state
Mm-hmm.
to go after them.
Okay.
Then, so that's, to me, that was one of the reasons why we're doing this. So, Representative Spear. Yeah, okay, you'll be next.
I haven't seen the latest amendment, but I've gone over the last previous amendment in a great deal of detail, and it looks pretty okay to me. But there were two things that I didn't really quite figure out what was happening. The DAO is going to be registered with UNH's IOL lab. Is that a contract that you see that the state is going to have with UNH, and who pays for that? Because there's no fiscal note with any of this. So I don't get the idea of how that relationship is supposed to happen. And I had a second question after that.
yes, I can address that. So in the original state budget, there was $1.5 million for UNH to develop blockchain capabilities. So that would have, but the
I never
Senate,
noticed.
the Senate pulled it out.
Oh,
So there may be other funding for UNH, but this amendment, it does reference UNH, the Interoperability Lab, which is a great place to tour if you want to go see.
yeah.
If you're a computer
that's-
geek, it's a neat
Oh,
place.
so you're not going to specify,
So
'cause like
so we
the old
backed away,
amendment.
just made it more generic, and there's the last page of the bill talks about the Secretary of State putting it out for an RFP.
I see.
We may have a few wrinkles to work out with that exact process, and it could end up being UNH Interoperability Lab, but we'll open it up to bid. That's it. Yeah.
My second question, or maybe it's an opinion, I don't know. So I looked at a bunch of other DAOs, and one of a DAO that's like out there that's kind of typical for stable coins is MakerDAO. And they are actually developed, they have their own cryptocurrency, they have DAIs, and that one DAI equals $1 and all that kind of stuff, whatever.
Right.
But what I see in other countries, and I haven't looked at the states, and I have not, so I'm lax on that, is the notion that a DAO has to have some, in the legislation for the DAO, has to have some notion of that the DAO has to implement anti-terrorism funding techniques, and which I think are
KYC,
what is it?
AML. Yeah.
Know your customer kind of thing, and the other one for anti money laundering.
Yeah. So those are still open questions with the
So we
DAO.
didn't do anything with that yet.
No, but all other federal and state laws would still apply to a DAO. So it doesn't, just like if you created an LLC and you were financing terrorism, you'd still be, responsible for that.
Yeah, I do see it explicitly said, like in Switzerland and the UK and other
so-
places.
So our banking statutes, if a DAO was involved with banking, our banking statutes would apply to the DAO if it was in that area of, if you look at the end of the,
So is it like being incorporated in? I mean, is it that you choose the state that they're choosing when you create this, that you are going to be administrated by this statute, by the
Right,
by the,
right.
the laws in New Hampshire? Because most corporations have that on their documents. They'll
Would you-
say.
I'm sorry, I didn't.
So most corporations, you'll see in the fine print, all that stuff. They you can't barely read, but you can. It's in there. It says at the end of the day, if you want to sue them, what court you sue them under. In other words, if there is a problem, they're being administered by X state. They'll have a state. In most cases, corporations at Delaware.
What I'm concerned about specifically is if we don't say something, does that put the state, forgetting about the Dow, does that put the state in a liable situation?
No, it's the state is this. It just means it's going to come to our state court. So if that's a liability for the state courts to have to handle the case, but at the end of the day, then the person, the two people who are suing each other are going to be paying for their court case. I mean, it's not the state. It's not. We're not. It's not. It's not the. I don't think it's the Attorney General's office that's going to be pursuing the case unless, unless it was clearly a class action suit or some kind of suit that was related to New Hampshire citizens. But
I'm
that.
worried about it, the feds go after us. I'm not worried about somebody suing us. Oh, yes, they do.
Well, feds would go to a federal court anyways.
yeah.
Okay.
They would ignore state courts.
If you feel comfortable with it, that's fine with me.
Yeah, no, I'm very excited about this.
So I just want to point you to page 18, line 22,
On which version?
on the one that you have printed out in front of you, I think, the one that was handed out. So it's, it's amendment number, unapproved amendment number 2327H. So page 18, line 22, in the amendment.
All right, that's helpful. That's helpful.
So I'll just read it real quick. Application of other laws. For avoidance of any doubt, a New Hampshire DAO shall be subject to all other applicable laws of the state of New Hampshire, including laws regulating securities, activities, banking, and financial activities, taxation, and all other provisions of law. So, right. That's one of the improvements that we made.
That was one of the additions. Okay, Representative Herbert. You need to turn your microphone on and
My
pull it
first-
nice and close.
My
to the
first
microphone.
question is, I have trouble with the English language, I guess, because it says decentralized, a DAO is a decentralized autonomous organization. So I'd like to know what autonomous means in this particular usage. And decentralized, I would like to know what that means to the promoters. And is there a political ideology involved here? What's the philosophy?
Yeah,
Right?
so democracy
Because to
would be
me, decentralized autonomous is almost an oxymoron. I
Well,
mean,
not to me. I mean, no, okay, so I'm going to be the neophyte in the room on this one, okay?
Okay.
All right, autonomous is any corporation, any entity is autonomous. It's standalone, it's autonomous by itself.
Yep.
So decentralized is that, like when we think of most corporations, well, you've got to start with the top. Who's the chairman of the board or who's the CEO? And decentralized means no, we don't have that corporate structure. It's decentralized so that every member of this DAO is equal. There is no CEO. There's no one person. So that's what that decentralized autonomous means to me.
That,
there's-
that can be one version.
There's some definitions in the bill that might be helpful. On page 2, line 20 is decentralized autonomous organization. So that's the beginning of a definition. But the real meat of it is on page 3, line 18. It talks about a decentralized governance system. And that has some thresholds built in it so that one person can't have an outsized controlling stake of the organization. So I'll just want to make one nuance. Okay, you mentioned MakerDAO. So MakerDAO has a stable coin, which is a token that represents $1, and they manage it so that one DAI is worth $1 constantly. It doesn't fluctuate like other. But they also have a governance token, and what we're talking about is the governance token, right? So the governance token gives you rights over what decisions that organization makes. And so when you look at page 3, line 18, decentralized governance system, that's really the token that gives people the ability to collectively make decisions, if that makes sense.
Representative Burrows.
I have a concern, which is that, I mean, this is a complicated thing. It's a 19-page document, which we just got yesterday. I don't know about anybody else. I got back from California. I didn't even see this till this morning. And we haven't had a chance to discuss it, people who read it. And,
Well,
and-
we're not executing this bill.
no, I
today.
know, but and the bill came out according to this on the 10th of October. So it would have
Right.
been
No,
nice
we're
to,
not going to execute.
I understand that, but it would have been nice
No, no, no.
if we
This-
had had an
this- hold on a
opportunity to
second.
go through it.
This was available yesterday afternoon about 4:30
I
p.m.
know,
Yeah.
and I didn't see it
But this is
because
a work session, so we're not.
I understand,
we're-
Keith,
we're
but
doing
it
those
would have been nice if we'd gotten it before we could just all discuss it with some
It
intelligence.
wasn't possible, I'm sorry.
So what we will do is we will have another subcommittee, if we're still aiming for the November, so if we're still aiming for the November 7th exec session, which we don't have to, right? Because we have another week after that, right, don't we? So we do, but I would certainly say we can set up for the exec session to be in the afternoon and then have the subcommittee in the day before or in the morning. And which time, if concerns are coming forward, we will know it. I mean, at the end of the day, we don't have to pass this year. If you really want to wait a year simply because there's so many pages here, that's fine. We can be patient. Rome wasn't built in a day. Okay, so I sorry that we're just getting this now. But that, yes, we can, that I will absolutely give plenty of time for everybody to thrash it out. And since I will be out of country next week, you have a whole time to stir up all the trouble you want in figuring out what you want to do with this. And then when I get back, we can then see where we're at that time. Okay, so I'm sorry that you feel that this is being just
Well, I mean,
dropped on you.
frankly, we get a lot of things like this the day before. It's happened before, so that's my concern.
So okay, if I can interject, Mr. Chair. We do have a presentation that we could go through, and it would explain a lot of the questions that people are asking.
Representative McAleer.
I still don't quite understand how this is structured and how it functions. And Keith, you said represented, let's say you formed a business or a DOA with all of us, and you're going to make widgets. Do we invest money to be a member of this?
So the answer is it depends, right? So the governance tokens that give you the ability to make decisions, that they can be given away freely if you wanted to do that, or it could be a membership-based thing where you pay dues.
And if somebody has more tokens than another person, do they have more say? You seem to say that it was that was probably not the case, but if I'm relating it to a shareholder,
Yeah.
a shareholder who's got more shares has more say. Does that work here?
So again, it depends. It would be how the DAO is structured. So you could have a token-based voting system, or the more tokens, just like the more shares gives you more votes, or you could have like a non-transferable NFT, where it's like a digital ID just for you, and then each person would have the same number of votes.
Well,
So it would depend on how the DAO got structured.
a quick follow-up then,
Yeah.
but you got to come up with the money to start your widget factory. Where does that come from?
So that would be like real world things, things happening in the real world. So just like any company, you need capital to do that, right? So you need investors at that level. But a DAO doesn't need to a DAO can interface with the real world. It doesn't have to, depending on what its goals and purposes. So,
It's all in their bylaws.
right.
Okay. All right. So I assume that you want to see Bill Ardinger's presentation. Okay, you're on, Bill.
Good morning, Mr. Chairman, members of the committee. My name is Bill Ardinger. I'm an attorney at a local law firm, Rath Young and Pignatelli. I'm here in my personal capacity and not as a lobbyist on behalf of any client. I am at times a lobbyist who's registered on behalf of clients. But in this case, I am performing this presentation in my capacity as Bill Ardinger, who was the chairperson of Governor Sununu's commission to study digital assets and cryptocurrency, which issued its final report in December of last year. And one of its recommendations was that New Hampshire should enact a legal entity law for these decentralized autonomous organizations. And you have before you something that came over the email to the committee, but also printed out this morning, a PowerPoint presentation that I've prepared working with Representative Ammon that provides a section by section summary of the amendment that you also have before you. But before I really go into that, I want to take one deep breath back to the reason for this important bill. Things are changing out there. The commission concluded that these structures, blockchain, which is a type of software used across the internet. The internet itself is relatively new. From the 60s forward, my friend there from Digital was working with early stages from when we testified on this bill in the spring. And right now, the choice for lawmakers is whether to allow those developments to go on without adequate legal infrastructure to support them, or to provide a balanced, thoughtful, precedent-based legal structure that will try to encourage and provide stability to these organizations as they go forward. Representative Spear asked the most important question, which is, hey, if we create this legal structure, are we facilitating, and Representative Burrow, crime, terrorism, bad things? And my answer would be directly the opposite. And this is what the commission found after studying for 7-8 months, is that there's a divide that we're suffering right now. There's the technically proficient world, which is very facile with software, with the internet, with these structures. And then there's the legal system, which is backward. It is not yet upgraded. This is an old story. I'm looking at Representative Hunt. I've worked with you many years, over the years, with situations where developments in our economy, our private economy, were moving so fast that our laws got stale. And then in comes lobbyists for industries and stakeholders working with agencies to try to upgrade those laws and legal systems. We've done that, New Hampshire did, with corporate law through the 1800s. And that took a long time, but ultimately the innovation in the legal system of providing legal personhood to these corporate entities, along with limited liability for shareholders, which is when you invest your money, $1,000 for stock, your house doesn't also get exposed to losses. That innovation started in a general corporate way in New York State in 1811. It created, some scholars argue, the force and power of the growth of the United States economy to the point where we became a leader in the world. We've done this with LLCs. We've done this with statutory investment trusts. We've done this with cooperatives. They never had a legal system until the legislature took it upon themselves to upgrade their laws to provide this. In this case before you, you have a situation where there's a community out there in the world who say, there's no laws governing me. We're new. We're on the internet. We're software. Therefore, we don't have to comply with the securities laws. We don't have to comply with KYC. We don't have to comply with other requirements. This exists. But when states are proactive and start recognizing this economic activity with sound legal structures, the answer becomes, Representative Spear, that section that Keith just quoted. That was an improvement that happened since the original presentation of the bill. It is because there are stakeholders who are not just technically proficient people, they're state agencies that care a lot about the jobs that they have. And many of them had served on the commission with Keith and me and others. So with that background, I would just say that the presentation goes through section by section what this bill does. In summary, what this bill does is pick and choose provisions that this legislature has already adopted. Some of them I've had a hand in drafting over the years as a lobbyist. Things like statutory investment trust. I testified in front of this commission years ago. We needed it. Why? Because it was going to bring to this state economic development, sound, and jobs from the mutual fund industry. And it did. I also sat in front of this commission to urge this committee to urge modernization of trust laws. Representative Hunt suffered through those presentations. That bill was 4 times as long as this one. But it has had a modernization effect that has been beneficial not only to industry, but also to people who want to do things like establish trusts for their pets. This is modernization, and I sit before you today to say what this bill does is by looking at precedents in our law, it recognizes the uniqueness of this activity, which is it's happening not in a way that appoints directors and appoints a CEO with a centralized corporate structure. Other states are making that mistake as they try to upgrade their legal plumbing to provide and support sound development in this industry. This bill recognizes that the newness of these entities is that it's happening interactively among decentralized computers all over the internet. Without an active internet, these organizations couldn't be there in this way. That is because of the internet. This is a progressive use of the internet to provide potentially a structure that can make innovations that are really important to humans. May these organizations perform activities that are not good for society, just like corporations. But if you make clear that your laws that are sound and that they apply to these organizations, perhaps you will be part of the innovations that, like New York started in 1811 with corporations, that ended up with Delaware having, a significant part of their state's economy operating on sound legal entity laws. Is it boring? Yes. Is it nerdy? Yes. But it's really important. The plumbing in your bathroom, the granite of your countertop, the fixtures are beautiful and they're fun to look at. But guess what? They don't work without plumbing. And that's what this bill is part of. So I won't go any further other than to say, as a chair of the commission who spent 9 months working with experts and others and agencies, I believe this is important for the state to take a lead role in. Another change, I'll close with Representative Spear in this bill, is with discussions with stakeholders, the effective date of most of the operative sections of this bill is now set for January 1, 2025 under the amendment before you. The only section that becomes effective immediately is the one that instructs the Secretary of State's office to develop procedures and protocols for how this unique registry would work and who would operate it as a registration authority. I will last say that the UNH Interoperability Lab is a gem in this state. They are used by every structure in the world's internet economy to test how their software interacts with others on the internet. If this legislature, and it almost did, the governor was very supportive of it. It didn't happen because we have to have priorities in the budget. I was a legislator in 1980 and 81 for Cornish and Croydon. I know those prioritizations are tough, but we have the possibility in New Hampshire, I believe, with the combination of innovative legislation like this, with incredible knowledge of a governmental organization like UNH Interoperability Lab, just giving it a little bit of help, we could be the leaders in bringing these structures into the modern economy. And I think we'd benefit as a state, our families, our economy would. Thank you for, I'm sorry I didn't walk through the PowerPoint, but it's there in front of members to look at.
Especially since we obviously want to take some time to go through this.
Yes.
Anyways, so yes, Representative Burrows.
Thanks for that great presentation. You really made it easy to follow. I appreciate that because I'm not a nerd. Well, I am, but not specifically in terms of this. So if there was, let's say, a hypothetical, there's a large corporation in New Hampshire, could they morph into this structure to govern?
That's a great question. And it focuses on, in my view, the real distinction here. Corporations are, by their very nature, structures that use central authorities to make decisions. In this bill, there are definitions in order to qualify for the registry, the New Hampshire registry, which would be the first in the country, this kind of registry. You have to have a decentralized governance system and a decentralized structure. What that means is no one force, person, group may unilaterally change the rights of every other participant. And they're based on definitions in federal legislation. So in my view, a corporation, which is centralized by its nature, would never be able to convert to this, because to do so, they'd have to fire their CEO, they'd have to fire their CFO, they'd have to adopt a centralization structure that may have real legal agents in the world, the physical world, like a Dow could appoint me to accept service of process if someone wanted to sue it, which right now doesn't exist. And it's a very mess at the federal level. There are cases unraveling which this kind of thing would solve, but everyone's struggling with the uncertainty. So no, Representative, I don't believe a corporation would be able to morph into this unless it wanted to give up its fundamental corporate structure.
So do you see this as a viable option for a new company forming to go with this structure?
I do. I am a tax nerd, and I'm 63 years old. I am not as technically proficient as I would like to be. There is something out there in our economy that is building off of the incredible innovation of the internet that is allowing cross-jurisdictional collaborations to happen in ways that they never did in the 80s when I was a young lawyer, right? So I think the answer is this is coming. There will be younger people than me who will see the benefits of this. I already just met a friend that Keith brought in who's working in this space, and he, who is technically proficient, sees the benefits of this. I think that this could be something that creates organizations that are incredibly beneficial to people all over the world, not necessarily limited to a particular jurisdiction, but rather I can imagine one use of blockchain that was cited as a very positive development from a witness who was very skeptical of some of the current structures like FTX, which is under indictment, bankruptcy now, is she said, this structure can be used to efficiently allow people who are doing well in an economy like the United States legally to transfer dollars to their families. Right now, the international system takes gigantic fees on those international transfers. This could be rolled out in a way that is not, that is, you know, going to be a real innovation that helps families worldwide. Not, you know, so we have not yet seen all of the creativity of these uses, but by upgrading the legal plumbing, hopefully, remember, in this case, right now, DAOs don't have to register publicly anywhere. Their code actually is online. It is accessible, but the governmental status of the entity is uncertain. This requires, in order to get the benefits of this statute, just like corporations, you have to register with the New Hampshire Secretary of State, just like another entity. So that transparency, you have to, in order to qualify for this, you have to post your code. You have to post written bylaws that a layperson can understand. We all know bylaws are hard to. So yes, I think this could be the basis for something positive. And with good agencies like we have in this state, DRA, securities, banking, AG, consumer protection, I'm hopeful that the development will happen in a way that is helpful to people, and they will help ensure, in addition to the transparency and openness that's required, ensure that negative stuff is minimized.
So you're saying I'm not going to be alive to see this because I'm older than you?
I think, Representative Burrows, you and I are going to be alive to see this. I don't know that we will be the leaders who will be implementing this with code on the internet, because I think we'd have to learn a lot before we got there.
Unless you have a lot of free time.
Yeah.
Representative McAleer.
Thank you. You're obviously very knowledgeable about this stuff, and my question is: do you see any? If you looked into the future, do you see any shortcomings that this potentially doesn't address? I mean, again, things are going extremely fast. We're just catching up. But is there something missing, or something that is going to happen in the future that we're going to have to catch up some more on?
The answer is number one, yes, but I'm going to tell you why it's a good thing that we passed this bill. The LLC didn't exist in the United States until the late 70s. Wyoming was a leader. New Hampshire didn't adopt the LLC law until the early 90s. I was part of that adoption. Has the LLC law in New Hampshire been amended many times since it was originally conceived in the first statute in Wyoming that was adopted? Yes, sir. Are those amendments bad or indicative that the original bill should not have been enacted? Absolutely not. It was without that original initiative to say and signal to the world that we are intending to be establish a legal, stable environment for this development, we would not have had the benefits that LLC law has provided. But yes, sir, there's going to be amendments to this bill and to others across the country for years to come. It will not settle. The developments will.
Thank
But
you.
we will at least catch up a little bit with what's going on in the world.
Thank you.
Representative Herbert.
I'm in politics. So right here, we're doing politics. And I have yet to understand exactly the philosophy that is generating all of this. I can understand that technology is going, always has been, going so fast. I mean, AI is all the rage. And but you need a philosophy, a political philosophy, in order to have me, and I think most people, be comfortable in what you're trying to do. Now, when I said autonomous means you regulate yourself. Decentralized means that I am deregulated, I am autonomous. I have a problem with that concept because it sounds exactly like a libertarian philosophy. And I have a problem with libertarians. So this is a political argument. So when I asked you, or I don't know if I asked you, but my question was, somebody please give me the philosophy behind it. Now you're giving me a little taste of it in the sense that I can see where in the speed of the world now, I'm not sure that having everybody do their own thing is the right way to go. I actually, armies are centralized, corporations are hierarchical, okay? And now you're talking flatland. And I'm going, geez, I'm not quite sure that this philosophy is going to work, right? Everybody's doing their own thing. And then you come in and say, well, no, the laws here will be adhered to. Okay, so you're not really autonomous. Okay, you can be an independent, but you have laws around you to protect us, and that's politics. And so I'm coming at it from that point of view. I need to be persuaded that this is what the philosophy behind all this is, and so I can understand where we might be headed.
Representative Herbert, I appreciate your question. I can imagine a libertarian view saying, I don't need laws about private property. I don't need laws regulating private property in a caricature sense. I don't think this is accurate. And what you answer back is, without laws about filing a piece of paper with the registry of deeds in counties, nobody has clear private property. Without a legal system, you don't have the things that we hold dear in this country, these private rules. I would say to you, Representative, the corporate law does not have a political philosophy. It is something that enables individuals to come together. There are corporations whose leaders are very strong, progressive, registered Democrats. There are leaders of corporations who are very strong, free market Republicans. It is not the legal infrastructure that enables and clarifies the legal status of that corporation that comes at it from one way or another. In this case, having sat for 9 months on the commission and learned about this, what I found is that you have political personalities from all across the spectrum, just like every human endeavor, who are taking advantage of these technologies to deliver services and products and opportunities to individuals who want to come together for that stated purpose. The only problem now is that when they come together, nobody knows what the consequences are legally. So this law is not tilting one way or another. I would submit respectfully, Representative, that your reading of autonomous as unregulated in this bill is absolutely wrong. It's not. This creates a transparent legal system like the corporate law, like the LLC law, like the statutory investment trust law, like the cooperative law, like the trust law, that says New Hampshire's state laws are modern and they facilitate sound economic development and growth for the benefit, hopefully, of people who live in this jurisdiction. And I think that this is not political. This is about a balanced legal structure that can be used by human beings trying to achieve their goals like the American dream.
Sounds great. And I need the details.
And I think I would urge you have had a chance. If you
I-
take,
let me- let me-
sorry,
let me go.
sorry,
That's
Representative.
right.
Sorry,
So-
Mr.
It's a
So
political argument.
you have to know is that he has in the past voted against all blockchain
I
legislation.
understand. I'm sorry.
So-
I'm sorry.
so he
if
is-
I had my good friends
Right.
here who I've worked with for years from the lobbying group, they would have been slapping me in the back of the head with that knowledge.
So-
But I care deeply
But
about your comments.
I think you actually hit the nail on the head when you say it is really when it comes to a libertarian,
Yeah.
this is anti-libertarian, because libertarians would say is they don't want any laws. They want it to be the Wild West out there. They want it to be a free-for-all.
So what's decentralized mean?
Let's okay. So let's just say that these words, these are just words, okay? And sometimes when I read a bill and they have these other references, and I have no idea where they're coming from with us. So I would say is forget about the title, forget about these words. Think in your mind what we're about to do here is very similar to the LLC statute, which was we are now creating a new incorporation vehicle that is different, okay? It is definitely different than any other incorporation vehicle that we've had, right? We started out with S corps, or B corps, and then S corps, and we even have B corporations, which are promoting to both to be politically correct and doing sound environmental things is a B corp, believe it or not. So we passed that in New Hampshire. Okay, so this in LLCs, all of that is we have different structures. So in this room we have the Secretary of State, we have our corporation division here. Okay, and they're saying is that no libertarian would ever intentionally want to be registered with them. Okay, we are forcing them to be registered, and we're doing it by the forces is we're attracting to them to have this structure to give them that integrity, whoever business is doing it, so that they are not criminally involved. Criminals don't like laws, right? Criminals, if you want to do a criminal activity, you would not want to be
You
in this
use
corporation.
crypto, do some washing.
But this is not crypto,
Well,
okay? This
a
is
lot
not.
of the language in
I
here.
understand the
lifted straight out
blockchain
of it.
concept makes it feel that way, but at the end of the day, the most important thing is that you have to register with the state.
Well, when I
okay.
heard that,
Okay, that's
took
that
a-
takes
took a leg.
that
I
takes all
understand.
exactly all the other stuff that your fear of blockchain is that now you have to be known. You have to have there's bylaws that are up on the web. You have to have all your rules and regulations and what you're doing has to be public information. Representative Spears next.
So, and this is for Anita's benefit, I guess. I spent a lot of time over the summer going through this in excruciating detail. And the DAO community and crypto community is a little bit like the Wild West right now. And the idea that we have some really thought out laws and registration this whole thing, the bill, I think is a terrific idea because it's going to have, whether we want it to or not, DAOs exist. And by the way, I found dozens of different kind of DAOs on the internet. DAOs that rent apartments, DAOs that buy land, DAOs that buy art, DAOs that create art, DAOs that create money, cryptocurrencies, DAOs that exchange stock portfolios, all kinds of things. And if we don't get some laws around this stuff and make it so that it's controllable to the extent that we're not taking advantage of constantly, and investors can actually invest in these things and not end up like FTX and Sam Bankman-Fried and lose $8 billion overnight. We have to have this. We have no choice. We have to do this. The technology is moving whether we like it or not, so we gotta get our heads around it. And it is a little complex, but it's not that bad. It really isn't that bad. And hey, I know I do read automobile manuals for fun. So for me, this is really not as bad as that. So look at it as a good thing.
Thank you, Representative Spear. Okay, Representative Calabro.
Very quickly, I just wanted to clarify something here. At the beginning of Representative Herbert's statement, he said we're politicians. And I take umbrance with that. I am a public servant. I am not here for a political party, and I don't sit here and work behind the scenes with everybody on this committee as a political entity. I need to clarify that. Thank you.
Would you believe?
I don't know. It's not a bad word in my
Okay. Any more questions? Thank you very much, Bill.
Thank you.
And we'll look forward to seeing you again.
Thank you all for addressing this nerdy topic, but it's important. Thank you.
Okay. And we're ready to move on, and we're not going to take any action, and we'll.
What about Securities, can we hear?
Oh, sure, absolutely. Securities and Secretary of State's office. You guys want to come up and tell us how you feel about this bill?
Thank you, Mr. Chairman. Erin Hennessy, Deputy Secretary of State.
And Tom Connolly, Director of Corporations.
Our Security Director could not be here today, but we are happy to answer any questions you have. I haven't had a chance to read through the new amendment, but I did read through, and we spent a lot of time in our department discussing the previous amendment to this one. So we are happy to work with the committee. If you think we are the best department to organize this, and I think it does make a lot of sense. We would be happy to do that. I did speak with the sponsor about the fiscal impact to our department and that there might be a fiscal impact. We would need to have some expertise in this area to help us out to especially create the RFP for this. I can see us creating a blockchain registry for this, which would also be I believe something first in the nation to create a blockchain registry for the purpose of blockchain or DAO companies. Anything else you want to add?
No, other than the okay, the better. There you go. In terms of the new section that was added, I'm sorry, Tom Connolly with Director of Corporations at Secretary of State's office.
How long have you been Director of Corporations?
I've been director for these last 4 years, and also served previously in that job for 4 years.
Okay. Good.
Yeah, in terms of the new duties that have been added in the current the new amendment are certainly things that this office certainly has the ability to do. Certainly say we need to bring in some expertise, certainly from the technology side, but our ability to find out exactly and analyze what other jurisdictions are doing, certainly been following this very closely in the various developments with regard to DAOs around the country. I know that let's say Utah's law will go into effect in January, and they're currently building a process to be able to register DAOs. I know Virginia has been working on this as well, as I said. So I think we can't move too quickly in terms of being able to provide a structure here that's going to be helpful in terms of being able to identify these entities. We first started with the original bill. there really wasn't any structure there in terms of the fact that we'd be creating a new business registry, but again on a blockchain concept is very exciting to us certainly, and the fact that we'll have a place where when someone wants to create a DAO, they'll start out by first indicating their intent to do so by filing with a notice with us, the Secretary of State's office, and we'll ensure they have a registered agent for service of process, and then they move forward with the accreditation authority to meet all the requirements of the DAO. So I think that's a very interesting concept. Certainly, it should be certainly workable for us.
Okay. Questions from anybody? Yes, Representative Herbert.
I need to see, like you said, the LLCs only came around out of Wyoming of all places, but apparently Wyoming is into this. And I'm not at all comfortable at this point with the concepts here. They sound good, or in a vague way. I've still not, I mean, the provenance of cryptocurrency was crime. So what does this come from? You know, why is there suddenly this huge push in order to rewrite our laws, decentralize, which has a connotation for me, and autonomous also has a connotation for me, and libertarian fits. I see red flags go up everywhere. Now, how long do you think it will take in order to, because this has been 2 years and they're working really hard trying to get things together. How long would it take to make me comfortable that there is some control here? That this is not something the government has a responsibility to the citizens. I don't want to put them in danger. I mean, it sounds good. What's a token? A token was a ticket. A ticket we already have. Now, a token goes through the internet and maybe it becomes real fast and doesn't cost as much. And I'm okay with that. But I just know from experience that the ones that go like that and say, man, I know what I can do with this, are not honest people. And that's why I'm very worried that I'm not at all satisfied at this point, and I'm just trying to get something from you. When are you going to be able to satisfy me? That is this. No, it's going to take a while because this is complicated stuff.
Yes, Representative, again, just like I said, I'm not sure that I'll be the that will satisfy your concerns. But one of the things that we find attractive about the bill is that, for example, anyone who's going to create a DAO, number one, is going to file an intent to do so. So our Bureau of Security is going to know from the get-go when someone is creating a DAO, they can look at the structure, they can see the bylaws, they can see the process. If they fall into the definition of securities, they're going to have to register. They're going to have to be regulated. So from that perspective, I think we feel pretty comfortable that it won't be 1,000 DAOs formed the first year. It's going to be a small growing process, but it will allow our infrastructure to be able to identify these folks, see how they're organized, and then be able to follow through to make sure they're following the banking laws, the securities laws, insurance laws, whatever is applicable. One thing too about these entities, which I also find very positive from a consumer point of view, is that right now, if you form an LLC, after you form the LLC, the only information you have to give us is the name of one of your members or a manager. We don't know who all the owners of the LLC are. We don't know what their operating agreement is. We don't have any information about. There's no transparency there. With a DAO, everything is completely transparent. We'll be able to see the process that decisions are being made by the entity, as well as if they appoint any administrators, the names of those persons are going to be on the web. We're going to know exactly who the people are that are behind the DAO in terms of taking any actions on their behalf. So there's a great deal of transparency that makes it available to consumers, whether they're members of the DAO or not, which we also think is pretty attractive from a consumer protection point of view.
Representative Spear and then Representative McLeod.
Just a quick comment. There's a difference between a DAO and these laws. The DAOs are out there, whether we like it or not, or don't like it, or do like it, or whatever. They're out there. This is just to herd them in and to control what access we as investors have to be able to understand what's going on with the DAO. But these laws don't create DAOs. These laws allow us to control the DAO and to have transparency with the DAO. So there's a difference. And DAOs are out there. You're not going to stop it. They're happening because they are legal in the United States.
Good point. Representative
Thank you.
McLeod.
Do you see any element of the DAOs as a security?
Thank you for the question, Representative. I think it depends on what kind of DAO that it is. I'm sure there are some DAOs out there that do sell securities, but there's others that may be like a condominium association where they just vote on things that happen with their association. So it depends on what the DAO is set up to do. It's just like any company.
So not only might they have to file DAO information, they might have to actually file as a security, correct? In some instances.
Yes, and I think that Representative said on page 18, line 22, that this would not prevent them from, or they would still have to follow all other applicable state laws.
Thank you.
Can't skirt it. Okay, so I was going to be done, but Representative Emmett has urged me to have Kumar, Baka, come on up and give us a story or two. Tell put some meat on one of these bones for us, so you have an idea of what we're talking about.
My name is Kumar Bukapatnam of Manchester, New Hampshire. My background is in mathematics and cryptography, and I work in the asset tokenization space. I would like to clarify, while we have been calling these organizations DAOs, a better rhetorical term from the comments I've Herd would be an algorithmically governed corporation because that is what it is. Instead of having, let's say, a CEO or a board of directors make corporate decisions, we have an algorithm that controls the corporation, controls what it does, and what this bill would in effect do by creating a registry of these algorithms is provide sound legal structure for this new form of corporate governance that has made its way to this stand. I mean, the primary reason why I'm in favor of this bill, in addition to all the reasons spoken about, is that fraud actually will decline quite a bit if I'm pitching a DAO to my investors or clients. I can open up the Secretary of State's website and say outright, this is the algorithm, this is how this investment or this firm is governed. And there is absolutely no way that any investor can manipulate, and engage in acts of fraud that they actually would be able to under traditional corporate governance, as we've seen with FTX and Sam Bankman-Fried. In addition, this bill would also greatly encourage shareholder participation. Corporate voting at best is very difficult and at worst Byzantine, which leads to most of us, even in our investments, throwing our vote away to proxies. By allowing a cryptographically secure corporate voting method, we can directly interact with our corporation and we can express our opinions without a chilling effect because algorithms are not susceptible to power plays and conflicts in the same way people are. And finally, if anything, this bill would, similar to New Hampshire's trust laws, bring a lot of domestic and foreign wealth to the state, which is why I'm here testifying in favor of this bill. Thank you very much for your time, and I'm open to answer any questions.
Any questions? Oh, Representative Herbert has a question.
Algorithms
Mike?
are your expertise as a mathematician. I'm assuming that you've actually written algorithms and know all about them.
Yes.
Now, the idea is, one of my concerns is that nothing is perfect. And the first people to find out where a weakness is are usually going to do something illegal. Now, that's just history. So I need to know that these algorithms, I've heard, somebody losing an algorithm and the money is gone, and some guy went into a dump in England. I mean, it was just outrageous. But I need to be, I am not secure yet with this push, and do algorithms ever make mistakes? I mean,
To allay your concerns, I would say that algorithms are in no means perfect, but they are a lot better at managing than humans because we are prone to error and arguably more so than computers. And to your point of, let's say, losing your key, it is a lot more difficult to, let's say, lose a key than lose that much of cash stuffed under your mattress. In that sense, algorithms are much more secure, and even when they fail, because algorithms do fail in a similar manner that humans do, they fail predictably, which makes the legal recognition of DAOs, or as I would say, algorithmically governed corporations, necessary to encourage corporate innovation.
okay, just one follow-on.
Follow-up.
So if you're helping the state of New Hampshire write these laws and everybody's learning more and more about them, does this mean that we need to have somebody with your kind of skill set at, we just talked to the corporate division of the state. Do we need to have somebody with your skill set as, a full-time employee? I mean, I'd be a lot more comfortable if there was that kind of expertise in the in our governance.
What this bill does is, all it does is, to the representative's point, the algorithms are out there. This bill just puts them in a registry, similar to how a limited liability corporation operates. I'd argue that the skill set that is necessary is the exact same as an LLC. The only difference is these corporations are being run by an algorithm and not people.
What time is it now? Okay, Representative Hammond.
Thank you for coming. I do want to make one point of clarification, and Kumar, you haven't had any input in this legislation. Is that correct?
Yes.
So there's no input, but we're open to suggestions from you. So
Yeah.
I want to make that
Yep.
clear. So this is how I envision the transparency aspect, right? So we all imagine X-ray glasses, that they sell them in the back of magazines. You put the X-ray glasses on, right? So a DAO is sort of like X-ray vision on how a corporation under the structure operates. You can see all of the decisions and the logic behind those decisions, like to a fine granular level. Would you agree with that assessment? If you
Yes. What a DAO effectively does is, by making the algorithms public, investors, clients, everyone can see exactly what is going on, bringing far more transparency than traditional corporate structures.
Great, thank you very much. Okay, I think we'll stop this now, and we'll take it up when we schedule our next subcommittee. And I think we were talking about what it was November. What was the November 7th? What day of the week was that? Yeah. Okay, so November 7th, we'll take this up again. All right, let's move on to the next bill. PFAS. Okay. Representative Spear, you're on. Yeah. Right. I don't know. Yeah, here we are.
Okay. When last we met, in a place far, far away and long ago, we had two bills, HB 242 and HB 465. Those two bills, 465 prohibited the sale of carpets with PFAS, and 242 prohibited the sale of food packaging with PFAS. Neither bill required that the state test anything. It was going to be some notion of a clearinghouse, and vendors would have to put certifications into their clearinghouse swearing that they don't have any PFAS in those components, products, and if they did, then they could sell them in the state of New Hampshire, and if they did not, they would not be able to sell them in the state of New Hampshire. One of the things that got me really bothered by this not by the bills, but how I got into this PFAS thing was I was looking at the discovery materials from lawsuits that happened to DuPont and 3M. For 30 or 40 years, DuPont and 3M knew that they were poisoning their employees. As a matter of fact, one of the cases that settled in 1998 required DuPont to publish the results of their findings. In the real world, you would not be allowed to do that kind of an experiment on any set of people. They published information that said there was no impact. When they figured out, when they were required by law to publish the results, they found out that PFAS was causing testicular cancer, liver cancer, kidney cancer, and children born with disabilities and low birth weight. When they found out that the women who were working in those facilities were being impacted, they transferred them, as soon as they got pregnant, they transferred them out of the facility. A reputable company, in my mind, a reputable company would never have done that. But be that as it may. Then came the FDA, and the FDA says they don't test anything, right? In this particular case, I don't know if they test anything in any other industry, but they don't test in the chemical industry relating to PFAS. What they do is they get letters and reports from companies that say our components are safe, and the only thing you worry about are breakdown products, and those breakdown products are safe. FDA published two reports earlier this year, actually this year, but earlier this year, in which they said that chemical companies were giving them affidavits that said this stuff was safe, when in fact, in the public, research had already proven they were not safe. And so we couldn't count on the FDA anymore. EPA steps in and they start saying things about the water, and they put limits on the water. The infrastructure bill has now some money in it to try and clean up some of this stuff. 3M, in their lawsuit, they settled for $12 billion. Now, to me, being a jaded New Yorker, anybody who's willing to settle for $12 billion without going to court has something to hide. But that's just me. So all of that money is going to be used to try and clean this up. But cleaning up PFAS is very, very difficult. Okay. So the only way we're going to stop this is by getting it out of the stream to begin with, is to not letting it come in. Now, we have 3M and we have DuPont and we have Honeywell, and they are all part of the PFAS manufacturing industry. But there are 9 other companies in the world that manufacture PFAS, and as a matter of fact, the largest one is in China. And we get a lot of our clothes that are manufactured over there. So they're coming in with PFAS coatings. I don't know how we would ever even stop that, but maybe California is going to try. That being said, for due diligence, I have to get this paper out. I can't find it. 90% of the PFAS that's in our waste, solid waste facilities comes from food packaging alone. 90%. There are studies that have been done by both, I want to say, several universities, and I have papers on it, but I'm sorry, my brain isn't as fast as it once was. There are a number of studies that show that PFAS leaches out of the food packaging and goes into the food almost instantly of that packaging being put on the food. There have been blood tests that show how the PFAS has increased in people's blood from the minute they step in to the minute after they finish a meal that comes from McDonald's or comes from even microwave popcorn. So the PFAS that's going into the waste is leaching out and is going into our groundwater. And as a result of that, our groundwater is being polluted. And remember, I said 90% of the pollution that's in the PFAS pollution in the waste is coming from PFAS out of food packaging. So that's the setting that we're in. And the only way we're going to stop this is by not allowing it into the state. And there's bills in 24 states, and there's current active bills that have actually been enacted in 12 states to stop this. And unfortunately, we happen to be in an area that's been hard hit, worse than most others. We have the highest pediatric cancer rate in the country. We have the second highest breast cancer rate in the country. We have the highest bladder cancer rate in the country. We are being polluted all over the place, and it's not just PFAS, but that's a part of it. And I think as a legislative body, one of the things we have to do is try and protect ourselves as best we can. And this is something that's easy to do. So when we last met, John suggested, Representative Hunt suggested, that we combine the two bills. Since then, Karen Ebel has worked to combine the two bills and set up and more definition with the clearinghouse and worked with NUMOA and DES. NUMOA is the Northeast Waste Management Official Association, and they are collections of DES officials in the Northeast that work on these kinds of things. And they put together model legislation, which I just got the other day. It's a little more broad than what we want. It still is. It's better than it was, but it's still a little more broad. But Karen has been able to work with that and work with the bill that came out of Vermont and has set up something. And the way we're doing it is this. Rather than tighten up the definition of PFAS, because some people want it to be defined this way, some people want it defined that way, all different ways. We're just saying in these 4 products, and the 4 products are food packaging, carpeting, children's toys, and dental floss. In these 4 products, no PFAS. You can put it anywhere else you want, but you're not putting it in there. We're going to protect the kids. We're going to protect our food source. And keep it out of your mouth, for goodness sake. Because some of the new dental flosses are very, very slippery because they have PFAS in them. And you don't need that in your mouth. And because it's rubbing against your teeth, it's getting out. So we don't want to really tighten up the definition. Now, what the EPA has done, and I have the law right here, so if anybody wants to question it, 155 pages. What the EPA has done is they said, we're going to create a registry. Now, they won't include breakdown products, which I think is a mistake, but they said they can't at this time. That doesn't mean they won't in the future. So they come up with 1,447 PFAS chemical definitions. And what they're doing is they're tracking everybody who makes any of this stuff or makes a product that contains this stuff has to put it in their registry. Once it's in the registry, they will decide in a few years from now which are the ones that are coming in and that are hurting us the most. And then they will make the laws. Then laws will be enacted if Congress wants to. Otherwise, EPA doesn't have that ability. What we want to do is we're going to say, just these 4 products, that's the end of it. You put them on the registry. If you make any of these products, you put it on the registry. You swear that you're not going to put any PFAS in them. And you present specific data. Now, we have several of these clearinghouses already in existence in the Northeast. There's about 4 of them. In fact, one of them was set up by our own DES for mercury. So it'd be the same kind of thing, just the same exact kind of thing like the mercury one. And the reason why I'm not in a hurry to pass these bills right now is that database hasn't been set up yet. So it'll be set up very shortly, but they need a bill to push it, to get the things set up. So what I ask of you is this. If we put these 2 bills, and I'm looking at you, Representative Hunt. If we put these 2 bills on interim study for now, so that we can have Representative Ebel's bill, which does the things we talked about, can we commit to the fact that, first of all, that bill will come here and you can do your little magic. I know you can. And when it does come here, we give it a fair hearing.
I can absolutely commit to those things. You haven't shed enough blood today. I mean, obviously the speaker makes that choice, and
I know,
I
but you
will,
can-
I
you
will
can-
speak to the speaker, and then we'll bring it, and we'll
we'll give it a
absolutely
fair hearing.
And I would say it'll absolutely get a fair hearing. You know, obviously the big touchy point is the one polymer or two or more polymer, and the food packaging, because the Department of Health and Human Services is very leery how because they see themselves as the regulator of that rather than waste systems. So I'm just telling you now what I know will be the issues. Okay, but
Sure.
absolutely we'll have a fair hearing, and absolutely we'll, work to find a resolution. And I mean, I have to say, once I found out about the mercury and the clearinghouse concept, I knew that was a winner, and that was the right way to go.
And that
Because
sounds really good.
we're not creating a new system, a new process. That's what we're doing now. So in my mind, that is, if you're ever going to address the PFAS problem, that is the way to do it. Generally not. I think I'm signed on to so many bills this year. It's just too much. So
Thanks, Representative.
Oh, you're welcome.
okay. So yes, Representative Calabro.
Just really quickly, as the owner of a food service operation, basically, these clearinghouses already exist here in the state. So when I am ordering things, I generally select things that are PFAS free. I just needed you to know that it already is in existence. These companies that are basically national and international, they already have these things in place because other states are protecting against it. And they're trying to be preemptive, I would guess, of the liability issues. And they care about the welfare of the people they're feeding. So I have that concern with the products that I am purchasing, and I just need you to know that this is already in existence. Thanks.
Okay.
But it's not mandatory.
It is not.
Right.
Right. One thing I've been amazed at, and my wife Lindsay here, but every time I have an opportunity to ask people about, do you have PFAS or know anything about PFAS, they all look at me like I have three heads on. I mean, evidently PFAS is the best it's not out there. And I mean, even in a furniture store, they have no idea
Well,
about
there's a
PFAS.
lot of uneducated people.
Well, I don't know if
They
it's
don't know what it
educated. I would not say that I'm an uneducated person. The only reason I know about PFAS is because, I read the newspaper about what happened in Merrimack. If it hadn't happened at Pease, for the fire retardant materials and Merrimack with one factory, I don't think I would have known anything about PFAS. So, any rate. So the motion that Representative Spear will take each one up separately. We'll start out with what's the first one on the list? 465. Representative Spear moves to interim study. 465.
And 242.
Well, we'll do them each separately.
Okay.
Yeah. Okay.
So, just a question about that. This is the second year.
Yes.
I mean, it's going to be the second year.
Yeah.
Interim study, how does that work?
Okay, so interim study, that's good. Glad you asked. So interim study means this bill will hit the House floor the first week of January. So don't want to miss that week because every committee has the same issue that first week, and then I think in the second week, all these bills are going to hit the floor, everything that was retained, and if the interim study is passed by the full body, that means we will get a chance to talk about this again next September. And that would be after we've taken action on whatever bill. So historically, we always, we say, and at that time, and then at that time, the vote is recommended or not recommended for future legislation. But that would obviously be pending about whatever happens to Evil's Bell this coming year. But yes, we will get to talk about PFAS no matter what come next fall.
This bill can come up in the next session.
Correct.
Whether it's interim study or
right.
not, or not recommended for legislation, correct?
Well, the key element is that if we kill a bill, you can't reintroduce it. Okay, interim study is not a kill motion, even though people call it killing me gently, but it's not a kill motion. It's the bill is still alive, so absolutely the bill in the subject matter can be reintroduced in the second year.
But
that
not the
correct?
second year, but next session.
Oh, the next session,
It could be-
it's a clean slate.
Exactly.
You know, you could bring in the same issue every 2 years for the rest of your life if you know, as long as you keep getting elected.
Right, so I don't know why interim study, how is that?
Well, rather than kill it,
beneficial?
no, well, the interim study is to show that we still care about this issue. We have a vehicle to talk about it and it's just a baseline. So no, I have no problem with the interim study.
But
And then the issue comes down to is next year, whether it's recommended for future legislation or not recommended. And at that point in time, we'll
It just
talk
moves
about,
it-
we'll
it
talk
just
about what
moves it
happened.
Slowly, and it informs.
It
the
keeps
legislators.
keeps the issue alive. So, I mean, in other issues, it's like the committee could always talk about a certain subject matter and have that subject matter around. So, yes, Representative
Well,
Spear.
we talked about just a little bit about the definition of what PFAS is.
Right.
And the way it is in the two bills that we have here that we've been talking about is that it can be as small as 1 carbon fluorine pair, if you will. And there's been objections to that. In the case of Numoa, their definition is 1 fully fluorinated carbon and 1 partially fluorinated carbon pair.
1.5,
Yes.
killing me.
It's not really 1.5. It's the way the bond is.
Right.
Part of the problem is HFOs. HFOs are a type of PFAS that the EPA does not consider PFAS dangerous, because HFOs, that's the chemical that's used in like refrigerators and stuff, because as soon as it hits the atmosphere, it breaks down pretty quick. The problem with HFOs is that the breakdown products are very toxic, and they last for 30 years, and they land in the water. And they're even less filterable than PFAS chemicals are. But I'm not trying to ban those. They have a place, and there's people who work with that, and that's some other issue. That's another issue. We just want to ban whatever chemical you're putting in food, children's toys, carpets, and dental floors. So it's not the definition, it's the use.
Yes, Representative McAleer.
I'm a little bit confused. I thought that these two bills we will put on interim study and we look at them a year from now. But in the meantime, this combination bill will come up in the interim and we can vote on that. Is that correct?
Yeah. So we actually retained this first year is retaining. Okay. And so we could have, I would say, is if things were moving along faster with New Hampshire MOTA or the New England MOTA, we might have been able to amend one of these bills with that language.
Right.
But the fact is that no matter what, the effective date is going to be pushed out to 2025 anyways. So it's just that and I'm honoring Representative Spear and Representative Evil, the sponsor, that they requested that we would just keep these alive, interim study them, but that at the end of the day, we'll address this issue with the next bill.
Thank you.
Okay. Motion. We're going to vote. Yes, we plan to have another bill coming in this coming January. As you know, there's many steps in the way, you know.
Well, too many, obviously.
So,
I just want to vote on a bill, and if
got it.
nobody does, then.
Okay. All right, so the pending motion is interim study. The business committee, just for everybody's, is Representative Ammon, Cole, Thaxton, Hunt, McAleer, Herbert, Filio, and Spear. And I see Filio is missing, so, oh, that's right, he's an independent. That's right. You can't have him, you can't replace him because he's an independent. Sorry. You're right. Evidently, this committee is not equal, not 10-10, right? With him is okay. At any rate, all those in favor of interim study, please say yay. Yay. All those opposed? Okay, moves.
Moved by.
Oh, moves. Representative Spear, seconded by Representative Ammon. Okay, next up is House Bill 242. And Representative Spears, second by Representative Ammon, moves interim study. Any discussion on the motion? All those in favor say aye. Those opposed? You moved unanimously. Okay. All right. And last but not least, House Bill 173, relative to toilet facilities provided by restaurants. Do we have an amendment yet?
We do. It's in my email.
Uh-oh.
It came from, I forwarded it to you.
Oh,
It still appears to be stuck in my email. It came from, was supposed to go to the service, what do they call it here?
No, HCS.
HCS. It went to HCS, who I guess I thought was supposed to distribute it to everybody, but we don't have it.
so, okay. All right.
Other than that, it's
Let's see.
done. It's pretty simple.
You have it right now on your computer, right?
I do.
Okay.
They may have.
And I-
Can I get, yeah, I want you to send it to.
Carrie.
Yes, if you all got it on your phones.
I have it. Here.
Well, I couldn't tell it said it was stuck, so I hit it a couple times.
Yeah, I got it.
So it's from
Yep.
you, right?
Yes,
All right.
Just repeal.
Okay.
It's pretty simple if you're.
it's pretty simple.
You can just read it.
That's what I was thinking.
Okay.
It doesn't seem like it's worth the paper. I mean, to print it out 18
Well,
times.
historically, we've always said that we have to have that printed copy. Everybody has it in their hands, so that it's a security issue.
Okay, I'm good.
She was there,
Pretty simple.
so
It's what the guy asked for.
but I guess I could. Every rule is made to be broken. So does everyone have it on their toy? Oh, so it was just subcommittee?
It's just a subcommittee.
Okay. You want to, can you just?
You want me to just read it? Or,
All right, we're in brief recess.
okay.
This won't take long. I would say, I just read it. No, I only need to read one. There's a bunch. All right. All right, let's get going here so we can get to lunch. All right, so Representative Thaxton, seconded by Representative Hammond, moves ought to pass on the amendment, and he's recognized to speak to his amendment in motion.
Well, it's not really complicated. It's not like the PFAS thing. When we met last time, the request was made, the preference was that the whole section be removed, so that's what we did. And it repeals, I'll just read it for the sake of the record. The motion or the amendment is to repeal the following: RSA 155:40 relative to the requirements to provide toilet facilities and restaurants. RSA 155:41 relative to the penalty for failure to provide such toilet facilities. And the analysis is this bill removes the requirement that restaurants and other businesses that serve food to the public provide toilet facilities for patrons. That's it.
And so we have a new member of our committee. Welcome, Rep. McGoo. I think maybe we need a little bit of catch up on the issue around this bill.
Oh.
So it's my
I'm fine with
understanding,
it.
and someone correct me if I'm wrong, that there are building codes that
Building-
supersede this and
Correct.
and make this statute obsolete.
Right, that was the real point. The building, it's not like restaurants are no longer gonna have bathrooms.
Right.
The point of this was, this is redundant, and there were so many exceptions in it as it was with, but you have to have you don't have to have a bathroom if you're a food truck, if you're a hot dog stand, and various other things. So the suggestion was made, since it's already covered in the building code, that the whole section be eliminated.
Makes sense, yeah. I watched a lot of YouTube hearings, but I thought this one was simple enough I could skip, and evidently not. So thanks for the catch up.
Yes. Okay, everybody all set, right? Everybody remembers that day? All right.
Yeah.
So this is still the business. This is business still. Okay, so all those in favor of ought to pass on the amendment, please raise your hand. Sorry. 1, 2, 3, 4, 5, 6, 7. Okay. 7 zip. Representative Thaxton. Representative Thaxton, second by Representative Hammond, moves ought to pass as amended. Any discussion on the motion? Seeing none, the clerk does not need to call the roll. All those in favor say aye. Aye. All those opposed? So moved unanimously. Okay, we're done. I just want to let everybody know the first bill we're going to be taking up, the liquor bill. And there was you guys got it mailed out to you late last night, and I did not have a chance to read it. And I am making a couple of changes on it. And if you have it near you, where is that on the section 1? Cannot exceed. The current law is 10 days, so we want to keep the current law 10 days. But that's only if all the employees have had training. And then on Roman numeral, well, that is not Roman, little I, the second offense up, it has 30 days, which would still be the up to. That still leaves the commission to decide whether that was really the situational situation, which is the way we've always handled it with the Liquor Commission. So that is what I would like to take up as an amendment. But otherwise, we'll see you all at, those who are on the Liquor Committee at 1:15, and then health is, what do I have health at? 1:40, yeah, it must have been 1:45. Yeah. Yeah, 1:45. Okay? If you're on the business committee, you're all done for the day. Unless you want to see all the entertaining stuff that we do this afternoon. What's that?
198.
What's wrong?
ITL.
Oh, yeah, okay. Yeah, the social, yeah. No, I mean, and okay, we'll get started here. Um, and uh, okay, obviously this is a work in progress. And we have been moving along in terms of coming up with the right language. So at this point, this is where I'm at, and if we can discuss, and if anybody want to take different opinions of that.
Call it to order.
It's a subcommittee. But the judges rule we're in order. Okay. All right. To start out with is, I know the original bill was introduced as Elizabeth law. The problem when you put a name on a bill is that name disappears. It's not in the statute. And I have had times where people said, well, I thought you guys passed this law. And I go, So as much as I want everyone to know that we are taking up this legislation now in her honor, and that's important that we are. But at the same time, putting her name in the RSAs is not, and I have no control of it. It's just not going to happen. It's not. It would be lost. And I hate to have it been and someone say, why didn't you tell us that was going to happen? So I'm just going to be upfront that.
I think if they look up the bill, then I think they'll probably reference Elizabeth Croak.
If you
I mean, if you Google it or whatever, if you
No.
that will pop up. No,
No, it's gone. It just when it's in the RSA.
right. It's
Okay.
not
So the
name's
only
not in
time
there,
that name is there is chapter law.
but- Okay.
In the chapters, those yellow books. I don't know if you've ever seen. Every year they
Yep.
try to get us to take the yellow books, and
Yep. Right. I've seen them.
and they have extra
the
ones, and nobody wears them.
Right.
And that's the only place it'll ever be.
Yep.
So, and I just want to be straight, because
Good.
I think this is important legislation, and I think it's important that we get it done, and we don't without any pretense of what else it could be or not be. Having said that, I have to emphasize to everyone that this committee has had this legislation about changing the 10 days multiple times. This is not the first time we're revisiting it. It just happens to be coincidentally that we're now doing it when the department is working on their rules anyways. So it worked out. This is a good time for us to revisit this. I think, and I proposed it before, that the most important thing that this committee is going to get across is how important training is. That we need these employees to be trained, and we need employers to not think that's a place where they can save money and cut costs. So if nothing else, what this bill, what we're trying to do here is impress upon licensees the importance of that. So having said that, I think we'll leave the 10 days, but they have to get the training, which is Representative Cahill's bill that he's put in multiple times over the years, and we've never passed, but that we are now going to pass it. And that 30 days. But then if and given a severity of the case, that it's not going to stop at 10. It can go all the way up to 30. And that is done through the hearing process by the Liquor Commission. And then going on to the second offense, and that seventh offense is within a 7-year window. And at that point, you know, the training issues, the window of training is gone. So now we are going to go at least a minimum of 15 days up to 30 days. And as much as, you know, the hospitality business, or, you know, the restaurants would say 30 days is you might as well be revocation. They're going to have to make that case to the commission that whatever happened was not, you know, was not worthy of the 30 days. So, and then of course the third offense is revocation, but hopefully that will never ever happen. So that's where I'm at, and I'm certainly willing to listen to anybody have any feelings or differences on that. But it seems to balance both sides, but gets what I think is the most important thing is to emphasize how important is training, the training is. Okay. So if everybody's okay, then that's what the amendment that will look like when we take it up on November 7th. So I will, because we don't have the official amendment, I will schedule a subcommittee at 11:30, because I have at 10, I have Mr. Dow.
No.
So, what's that? That'll be November 7th. 12. Okay. No, that was, don't you remember who made that? It was George Senior Bush made that mistake. He came in September 7th, and he said, this day will live in infamy.
Okay, 11/7 now.
So,
11/7, all right.
okay. Any comments?
Nope, looks good.
Yeah, if you want, you know, certainly. Yeah.
Thank you, members of the committee. For the record, I'm Maureen Mooney, a state representative from the town of Merrimack. I'm here with Mr. and Mrs. Croak today. You may recall their very compelling testimony from earlier this year and their advocacy and idea for this bill. We're very appreciative of the work that you and the committee has put into this, and we look forward to taking it through the process in June, when hopefully the governor will sign it as it is. I also want to make mention that I want to thank in particular the governor, who has written now 2 letters of support for House Bill 279. 2. The second one arrived today, and I have a copy if you don't have one already. Also want to thank the Liquor Commission for their help and guidance and support of this bill. You've done great work, and thank you.
Okay, thank you. All right, we all set with that? Okay. I guess we could do a straw poll, right? Straw vote? Okay. So, all those who will be in favor of this amendment, please raise your hand. 1, 2, 3, 4, 5, 6. Okay. All right. Unanimous. All right. What's next? The next one's 145, right?
That was it. No, because we're all here. The liquor. Oh, for the next few. Oh, insurance. Yeah, I'm not voting either, but I'll help them with the paperwork. No, you're good to go. If you want to go, yeah. I mean, a lot of people just stay anyway because they want to hear how it went. But I mean, y- if y- I think you could speak if you want. You're not on the subcommittee, but I think. All right.
Okay. Last but not least, health insurance bills. Okay, first up, Senate Bill 198, directing the insurance department to conduct a cost study of providing coverage for certain reproductive health care. You're on, Alex. It- 198. Good afternoon, Commissioner. Oh, good. Your microphone, and then I've been told, because my wife was here earlier, that people have to really pull this thing close to your mouth. So if you're talking to it, and if you can't hear yourself, that means nobody else can hear you. So you actually, that they have it real well timed, so we don't have feedback, but you do need to hold it very close to your mouth.
Okay.
Perfect.
So,
Introduce yourself.
I'm Alex Feldwebel, health reform instructor for the insurance department.
I'm Michelle Heaton. I'm the Health Law and Policy Legal Counsel.
Welcome.
And the two of us were interacted with the external actuarial firm that did the cost study on this bill. And it's posted on our website. And would you like to hear a short description of the findings?
We like the executive summary.
Well, I'll give it even shorter than that. The study divides the costs up into two categories. One sort of general category for assisted reproductive treatment, and a separate category for preservation. And in order to make this calculation about cost, first there was a calculation about the number of people who would be eligible for the services, and then an estimation of the number of people who would use the services, and then that was multiplied by an estimation of the cost per service for a variety of services that are involved. And the first part of the study used a low, medium, and high estimate because it's very hard to pick numbers about the number of people who will be using the service. So it's more common to use this range. And the cost was expressed as a per member per month amount. So you can think of that as monthly premium. And the low estimate for the first part of the coverage was $25.25, and the high estimate was $100.30. The medium estimate was $50.25. So those are large numbers when you're looking at mandate coverage estimates generally. And then for the preservation part of it, I'm looking for that. Oh, there we go.
Two questions before we go on. Again, this is only affecting the small group, right? We're
Only the large group.
And the large group.
Only the large group.
Only the large.
So excluding individual market and small group market in order to avoid that issue.
Oh, right. The
Of defray, yeah.
unfunded mandate under the Affordable Care Act.
Yeah.
So we can force this onto large employers, or large employers being the over 51 to 100. Is that what the,
51 and above.
51 up?
Yeah.
Who were still buying the fully insured product rather than the being an ERISA.
Right.
So
That's-
how
is what was
many
studied.
lives or were they thinking that was going to pick up?
Well, the total, oh, there it is. I was just going to
Wing it. I saw that.
At 237,000.
Okay, 237.
237,000 is the potential pool, but it's very difficult to estimate how many people would actually utilize these
No,
services.
right, I
So that's
understand.
why we have the low, medium, and high. So based on the low, medium, high estimates, I think the low uptake was around 6,000 and high uptake would be around 23,700.
Right. So if we think that the average premium of the large employer is going to be 500, 600 per person, that medium of 50, that's 10%.
Yes, this would be a
Holy
substantial
moly,
increase.
this is,
So part of the problem with this mandate study is that the language in the proposed bill was very broad. So that opened up a large variety of potential services that would be included. And there's also language in the bill that this would be for a certain classes of people. However, that would be discriminatory to just single out certain classes to give them the covered benefit. So we kind of disregarded that because it would be discriminatory, and we applied it to anyone that would be eligible for these services. So those two factors really increase the cost. If there is going to be efforts to try to bring down the cost, some of the suggestions would be to limit the types of services or put in some kind of parameters about what specific services would be covered and in what instances, and that could potentially bring down the cost. But
okay.
this study considered that wide variety of services, so that's why the
Call
amount
it
is
the
very
full
large.
spectrum.
Yes.
Yeah, it was
Well,
a little bit unusual. Usually we get the proposed mandate already expressed in legislative language, and then it gets referred to us. And this bill was actually itself about referring the mandate, and we struggled very much with questions of interpretation.
Great. Okay, why don't you keep going? Unless you have any.
Oh, well,
did we get everything?
The second part, of the coverage that was evaluated. I've lost the page, but it was also significant numbers.
You're on it.
The low end was $9 PMPM, and the high end was $35 PMPM. And the middle was 18 for the preservation part of the services.
Yeah, you're got to speak a little louder.
Okay, I'll start over.
Yeah.
The low for as a express and per member per month for the preservation services was $9. The high was $35.50, and the middle was $18 per member per month.
Yeah. So, well, this was when you say express,
Preservation of egg and sperm.
eggs.
right?
That's right. Right. Egg chiller. Okay. All right. Yeah, Senator Representative Terry.
So as I understand it, in your initial presentation here or report to us, you're saying that you're finding the language of the bill as being overly broad. And also a second problem is that it on its face is discriminatory.
Well, no.
Because-
The way it was written, it seemed to leave no stone unturned in terms of all the circumstances. So there wasn't any kind of parameters that would have limited to who we could get the benefit.
So therefore, would you might not conclude that the bill's language needs work and would be open to amendment to address the concerns that you have articulated?
Yes, we've.
Because you didn't say that, but I'm kind of inferring that from
Oh, absolutely.
your very
There's
nice
the
report.
potential here for designing legislation that works in response to the report to limit the coverages to more closely align with, I think, what was intended.
So, yes, if I may follow. So, what I'm hearing is that the bill that you studied, the language that you studied, you would consider to be less than desirable and defective. I don't mean to be pejorative here, but it's deficient and defective and needs to be rectified in order to be able to be viable.
So what was actually in the bill that was presented to us was really a bill to create a cost study report, and it gave some very general parameters. It's not necessarily written in the context of if you were to implement a new mandate. It was not written in that context. It was really just to do this cost study. But when we did the cost study, there was no specifics really put into it. So that's why we ended up having to do this very general, very broad, considering a whole spectrum of services. So we would recommend, if you want to bring down the cost in future legislation, because this was just to do the study and the study's done. So I'm not sure that you would necessarily want to move forward with this. But if you want to introduce some new legislation on this issue, it would be advisable to include some definitions or some parameters about what specifically should be covered.
Thank you.
Representative Porcelli.
Do you know if, did you look at other states to see what their experiences were? How many other states?
So we did not do the analysis. Freeman did the analysis, and they did review other states. No state has legislation that's this broad that would remove the requirement of medical necessity. We do in New Hampshire already have a mandate on fertility services in the large group market, but that is limited to what's medically necessary. And I believe this, the intention behind this type of legislation was to expand that coverage.
Thank you very much. All right. Obviously, I guess first I want to make sure everybody understands that little conversation that Alex and I had just had there. And that is when the Affordable Care Act was passed, back when they called it Obamacare, I guess. And when it was passed, they were going to, originally the concept was they were going to come up with a menu of mandates that were going to be consistent and throughout the country. And then they realized that that was extremely problematic because every state had different mandates, had different elements. So they, you could call it kick the can down the road. What they said instead was that, okay, each state is stuck with the mandates that they have. And that after going forward, if you want to pass a new health insurance mandate, and this may be a reason why we haven't seen too many since then, is that the state would have to pay for the mandate. So the conversation that I guess I had, you know, I knew that the small employer, you know, was 2 to 50. In New Hampshire, we were 1. We were kind of controversial with our 1 to 50, but it was 2 to 50, and then when our what we call our fully insured market was large employers were 51 and up. So saying that, so I guess this is a learning lesson for everyone. If you see a health insurance mandate, be aware that you're not affecting the small employer or the individuals, which is really the ones who would be hurt the most by any new mandate in terms of premium increase, but that is only into employers that are 51 or greater that have not switched to an ERISA plan, that they are just still in the fully insured market, which we just learned there are 230 some businesses who are in that, which, yeah, excuse me. So, and that's a good, you know, that's a good 20, I don't know, whatever state's population, 1.6 million, so that's a, you know, a pretty high number. So, okay, who would like to make an inexpedient legislation motion? Okay, Representative Terry. Anybody want to second it? Representative Calabro? Any discussion on the motion of inexpedient to legislate? Seeing none, all those on the Health Committee say aye. 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 Those opposed? 6-0. Okay. All right. Next up, Senate Bill 235, relative to services provided through a primary care behavioral health model. Okay. And you guys have been spending a lot of time working on this, I hope. Right, John?
Alex has, so.
And others.
Is Alex, is his compensation off budget, or how do we handle consultants in our budget?
Part of the secret sauce, Mr. Chairman.
Right.
I consider Alex to be a successfully failed retiree.
Failed at trying to retire. Right?
So yeah, there was a good amount of work done on this bill. We felt we had a mandate from this committee to see what we could do by bringing the stakeholders together, both the carriers and mental health providers who were trying to bill under this primary care behavioral health model of care. Wow.
You're kind of mellowed in your old age.
I was always
you were
mellowed,
so much louder when you were the deputy dog.
Okay. There was good representation in the working group, both from mental health providers and from the carriers, and a spirit of collaboration. So it was kind of fun to work with this group. The problem that seems to have been occurring, which we verified in looking at the claims data, there was a fairly high denial rate for the specific codes that were being billed for this service. Is that some of the codes are quite new. This model of care is new, and it's not easy to bill correctly or to process the bills correctly because it's a new thing. So we identified that as one of the issues. And then there was a subset, or one issue in particular, that seemed to be causing the most problem, which was that a lot of these bills that were developed by those entities that develop these codes set up this mechanism where the payment has to be, or the bill has to be submitted by the billing provider, which in this model would be the primary care provider. And that makes it difficult for someone who, for example, just has a contractual relationship with the primary care provider, which is one way of setting up this model, to then have to bill only through that provider is difficult. So we identified some codes that we believe can be used for billing directly. And we have a bulletin that the department will issue, basically providing instruction to the carriers to make a special effort to review the claims that are coming in associated with this care model, to identify issues, and most importantly, to reach out to the providers and make sure that they are making it clear what the procedure is for billing under these new codes. So that's the plan.
Thank you, Mr. Chairman. What I would add to that, and the reason why I wanted to come up here is to share with you what that bulletin process is. I don't think we've had an opportunity to talk about that in any of the times that the department has appeared before the committee. So as all of you well know, try as hard as you might when you craft a piece of legislation, when you put a new statute into effect, it's impossible in all circumstances to get it exactly right, which is why you all have the GELCAR process, which helps to smooth out the rough edges, to help with the implementation process, to build up the structure around that law to ensure that you are achieving what was intended in the statute. For regulators, for us, we have another tool that can help with that process, and it's called the bulletin process. And so while it does not have the effect of law, and while we do not have to come before the legislature to achieve it, what it essentially amounts to is, based off of the statute or the rule, if there is a rule in place for this, this is how the department is going to interpret the most appropriate way for us to regulate this particular statute or rule. And so what Alex was able to do was to bring the stakeholders together in a very collaborative way and say, we can actually achieve this by the department clarifying how it wants this process to go forward. And so the beauty of that is we can issue that bulletin at any moment, and it will go into effect at that moment. And hopefully we can start to iron out some of the issues here. I will tell you that this is not the only circumstance where we have seen this type of thing. The state has brought on a number of different services over the past several years that need to have that billing process ironed out. And so I think what we've done here is created a very successful model for us to go forward and address some of these other issues in a number of different arenas.
I would have to say that I too have urged you guys to do bulletins over the years, and usually it's a procedural thing, and it's just letting the companies know exactly how they should handle it, and so yes, Representative Terry.
So would it be correct for me to understand that in your conversations with the parties involved in this issue, that all are satisfied, if not in agreement, that this is the way to proceed?
Yeah, I think there's a good consensus that this is a good way to proceed. We're taking the unusual step, in this case, of circulating a draft bulletin with that group to make sure that we have that consensus.
Good, thank you.
Yeah, and having said that, because I'm looking at John, who is the legal counsel, that for my best way to handle a situation like this is that we will interim study the bill, and so that a year from now you can come back and when we take up interim studies, you can come back and tell us, or John can tell us what has been the outcome of this bulletin and whether it's been as successful as we would hope. So, okay. Thank you very much. John, you want to weigh in?
Thank you, Mr. Chair, members of the committee. For the record, my name is John DeJoy. I'm representing the New Hampshire Psychological Association. And what the commissioner and Alex have just outlined is we agree with completely. My client is requesting that we not go to interim study just yet. We would like to see the draft bulletin because if depending on the draft bulletin, if we're able to iron everything out, which we think we have, we're happy to either interim study or kill the bill at that point. However, if not, then they want to keep open the option for a couple more weeks to move the bill forward. It is our expectation that the bulletin will resolve things once we can see the draft. That is the expectation we're working under.
Okay, so how long will you guys need to do this bulletin? Okay, because, so we're scheduling to exec this bill on the 7th, November 7th. So,
Bulletin should be on the street.
As I said, please don't hear this as expecting an adverse outcome. We expect
Right.
a positive outcome.
You're-
It's just my
right.
client would like to see the
yeah,
bulletin first.
you'd like to see the i's dotted and the t's crossed. Okay, so we'll hold up for our final decision on that come November 7th. Okay? All right, that's fine. We can hold off. No problem. Yeah, I mean, I guess we could. We're gonna come back and revisit. I mean, but I wouldn't schedule another schedule. So let's do the interim study motion, but that if the bulletin comes out and if it's okay, so let's take up the interim study. So I move interim study, seconded by Representative Calabro.
Before we vote, question.
Yes.
So by taking this tact of interim studying it,
Yeah.
it's easier to withdraw it on the 7th rather than to
Well, it doesn't make any
to make a
difference.
motion to interim study it on the 7th.
Right. I
So
mean,
you're
we
s- you're s-
generally
It's
we
6
like,
of one, half dozen the other. I mean,
Yeah.
you're preferring that we interim study it and then withdraw it if everything
Yeah.
works out.
exactly.
Thank you.
Okay, is the motion clear? All those in favor say aye. Those opposed, so moved unanimously. Okay. All right. Let me just make. Okay, relative to insurance coverage for pain management services, 303. Representative Calabro.
I would like to bring new life into this bill. I have talked to its sponsors today. What I've taken the time to do most of the summer is basically working on HB 66, which is a study to study the integrative model of collaborative medicine for chronic pain in the state non-pharmaceutically. What you have is 5 members of the House and Senate basically sitting there every 2 weeks doing research about this. And some of us have gone off site and done some research to find out how can we, and bottom line is make this efficient, effective, reduce emergency room visits, reduce the stress on providers like myself and keep them from retiring really young, and allow us to have some solutions here. And it becomes very obvious over time that the economic model of expanding care to include those licenses, medical licenses in the state, for those supportive systems, they're less invasive, they have better efficacy, they cost less. And in UVM, it showed us very plainly that 6 months of operation within their chronic integrative medicine model, and there were only 10 participants in that. Of that 6-month study, that was the same cost as 1.5 epidural injections. As a PCP, I find out that people have chronic pain because of how many times they've gone to urgent care, emergency rooms, how many time has been wasted, how they're abusing the Vicodin. I see this from the other side. And so I'm trying to open this channel of treatment options for everybody without a mandate. Because I think in time they're going to see what I already know with my degree in community health and psychology and in medicine, that this is a better model, it's more effective, it's going to free up a lot of things, it's going to save marriages. And I could tell you that the comorbid disorders associated with chronic pain, obesity, diabetes, congestive heart failure, we are tackling all of that. Now, me, as the mobile crisis medical lead of the state, I'm trying to save lives. I want to save people from Vicodin. And when they lose their jobs and lose their insurance and can no longer see their PCPs, that they don't turn to the street for fentanyl. And that's what I'm hoping to accomplish with this. Now, I spoke to the members of this committee who are not in the same party as me, and they are all in agreement with what we are trying to do here, and I would like to see the insurance companies do the right thing in time. I know a lot of them have already seen that, and they see that the benefits can be helpful, but I want to limit what we permit. There has to be guardrails, and that includes licensure for the state. If they deemed us capable of practicing medicine, we should be reimbursed for it. Now, I won't get into how much that fee-for-service is, because if you knew acupuncture only yielded $18 per injection, you would know that that's not a very affordable, sustainable model. But that's what I'm trying to tackle with HB 66, not with 303. Thank you.
Would you like to make a motion?
I would love for us to take it out of retention and consider it on the 7th.
Sorry?
I would move to.
Interim study.
No. We are not talking about an interim study. We want to move forward on it, I told you. I got the entire group to agree. Do we move forward with it non-mandated,
But
as amended? Nagel sent the amendments.
okay, I guess if that's what you were trying to tell me earlier, I'm sorry, I totally missed that. The sponsor asked me to.
And he corrected his changed it, which is what I told you before we came in here. He does not want to put it into interim study. He wants us to move forward. He agreed.
Yeah, well, okay. We're a long way. I mean, when I plugged in the bill and pulled up the bill and said, change all the
No,
shalls to
he
may.
sent it. He sent it to us a few weeks ago. The amended bill.
Yeah, but I took what he sent me
Mhm.
and I turned all the shalls to may. There was 25 of them,
That's what I.
but we didn't get that amendment. We don't have that amendment.
What do you mean?
We don't have the amendment that says may.
I thought he'd send that into OLS. Okay, I'll get him to do that. But that is what we had talked about.
Well, obviously, you're saying he tried to call me or talk?
No, he sent the corrected amended, and you corrected it, but I never got those revisions from you.
No, I don't think so.
Who's on first?
I don't. I mean, at this point, he told me to interim study the bill.
And he changed that when I told him that we had support here from other people and that we would
When
not
did you have
mandate
this
it.
conversation with him?
And I had that conversation when we walked in here, and I tried to explain to you that he would like to pull this bill out of retention. Gary Merchant would like to pull this bill out of retention. Dave Lundgren would like to pull this bill out of retention, and I would like to pull this bill out of retention. We're trying to expand healthcare access without a mandate. I don't see that being a complicated thing.
Well, here's the problem. What the bill does, even if we turned everything into May, okay, is a whole new process procedure. And what he told me was that they wanted to pursue that in 66.
We are. Let's work on the wording and the amendment. Let's take whatever it is that you're contending with out. But that is essentially what he wants to see happen, is that we limit it to 12 visits, that we include those professions that have the licensure, and that we not make it a mandate. The how we do it is HB 66's legacy.
Well, but the whole idea is this whole new way of looking at healthcare.
That's HB 66's legacy, not this part. That was what we talked about.
Mr. Chairman, so how do the two relate then? Why is one necessary for the other? I mean, just for illumination, so that some of us on this side who are
Right
trying to
now,
understand what's going on here. I mean, it's somewhat confusing. I'll just be
right now,
generic.
if I were for me to address chronic pain for a patient, I have 3 or 4 people I can call and my tools in my tool belt. Okay. What we're trying to do is expand with those codes, whatever those things for that chronic pain, that we extend it to various other entities who are licensed through the state as well, acupuncture, chiropractic. Most insurance companies are starting to include that, but not all of them. They're more effective solutions, sometimes shorter, quicker resolution and avoidance of ERs.
So my follow-up. So I'm still trying to understand the relationship between the two bills and how they relate to each other.
HB 66 was mandated by what I've been asked to do by the speaker is essentially find a model for the state to deal with collaborative medicine, to deal with chronic pain. We are trying to do that. It's a bipartisan effort. These stakeholders here today are there for that particular committee as well. And the research that we're doing is basically trying to figure out how to solve that problem for the state. I highly doubt we'll get it done by December. We will probably extend it through the following year and work on that as creating a collaborative model. What this is trying to extend is coverage for those services for chronic pain to include the other providers. Okay, but not mandate the costs, not mandate that they have to cover it. In time, they'll see that it is useful and it is going to save them money and that it is a more efficient model. Research has shown that since 2010.
So I don't know how long you want to prolong this, but I'm
We're in
still
brief
confused.
recess for 5 minutes while I call him.
Dave Nagel, I have his number.
So are these, so like the acupuncturists and whatever, are they not now covered? They're not considered providers. So this bill wants to make them, but not mandate that they be providers, because now we're going from shall to may.
That's right.
So isn't this still then it may becomes permissive? So what are we accomplishing by making this permissive?
Because it's opening the door for finding out what we already know.
So are you saying they need nudges, the insurance people? No.
But it takes a long time for that process to happen. It's an education collaborative effort. I don't want anything going down any insurance company's throats. I want them to come to this conclusion with us. And that's what we're working on in HB 66.
So why don't we have one bill instead of two?
Because it makes it more complicated.
To have one bill instead of two?
No, to make two bills.
Well, no, actually, you're describing what's going on here. It is more complicated. So we want to have a collaborative model, but we don't want to mandate it on the insurance companies. We want them to do it. But we need to use language like may, which is which is therefore has the effect of a resolution, right? A resolution which says this is the sense of the legislature. The legislature has the sense that this is where we would like you to go. We're not mandating you to do this at this point.
Yes.
Yes. Well, from a favorable point of view, you would say this is quite elegant, this procedure. On the other hand, I would say it's somewhat convoluted. And I would come down on the side of convoluted.
Okay, so what I would like to do is that actually, we have.
Does this get
we have-
easier on the last
Ooh.
bill, or I just need to know whether I need
Nothing
coffee.
ever gets easier. Okay. All right, let me make sure I got this down here.
I think we'll be able to legally have gummies when they become legal. Or is that like Europe?
Okay. Last but not least,
You can't tell them, but
relative prompt payments for managed care.
we just want you to be aware of what our sense is. What's the force of that? No, it's, just like nice. Be nice.
Wow. Oh my God. Are you going to read that?
Are these the handouts?
Jesus.
Do we get one of those? Do we get?
No, these are something visuals. These are visuals. Okay.
I really wish we had PowerPoint.
No,
Handouts. There was PowerPoint?
Yeah, that's a
no, we
That's good.
we got to help our tree paper industries here.
Look at all the paper we're waiting. We just have PowerPoint.
That's right. He was asking for a PowerPoint, and I said no PowerPoint. We've got no stinking PowerPoints.
Is this recycled paper? Or is this virgin?
No, it's Gene Chandler, who's from the North Country. He used to always tell me, say, oh, you gotta help the paper industry. This idea of cutting back on paper.
That sounds like Gene. Yeah, that sounds like
Right.
Gene. That's why I beat him.
This is too many trees.
I know.
We got to cut down on, carbon
Please tell me we're
emission.
gonna go through every page of this.
Recyclable.
Not when you throw it out. In Manchester, they throw out the recyclables.
Anyways, yeah. We had too many. Well,
Yeah,
let's
you know,
put it this way.
we throw everything away
At
now,
least they-
except for glass
At least they have
and tin
something.
cans.
That fancy colored printer they
You
have.
drive into the transfer station and all it says recycling mandatory. It's got all that glass, paper,
Yeah.
whatever, and then it says.
All right,
no
you're on.
Only glass.
Thank you, Mr. Chairman, members of the committee. Once again, my name is DJ Betancourt. I have the pleasure of serving as the Commissioner of the New Hampshire Insurance Department. You have met Michelle previously, you have met Alex previously, but wisely hiding somewhere in the back there is Jason Dexter, the head of our Life and Health Division, and collectively they have put this afternoon's presentation together for you, as we promised that we would. While today's discussion is ostensibly about Senate Bill 82, which is prompt payment of claims, we appreciate, and we hope as a result of this presentation that you will appreciate, that there are deeper underlying currents at play that have prompted this legislation beyond the narrow definition of prompt pay. And so therefore, we have crafted a presentation that hopefully provides you with some of the critical information about the core issues that many of you indicated to us that you have been hearing about. As you will hear, under the narrow definition of prompt pay, there are no issues in New Hampshire. Our carriers are paying claims slightly faster than the national average. That being said, at the same time, we know that there are issues with varying degrees of prominence with accounts receivable that carriers owe to providers. Therefore, I believe we can logically deduce that the issue is not prompt pay, as this legislation contemplates, but something more complex and deep. We are going to share with you what we believe those issues are, based on our observations and analysis. However, fundamentally, there are two major issues. The first is that the billing system is mind-numbingly complicated. And the second issue is that human beings, all of which of us are, of course, fallible, are trying to navigate that incredibly complex system. This is not to say that those who are responsible for billing on both the part of the carrier or the provider is not working hard, or they're not smart, or they're not doing their best. What I am trying to get across to you is that this is a system that is going to have its flaws. And despite best efforts, mistakes are going to be made. Therefore, to help you understand the complexity and provide context to what carriers and hospitals are struggling with, my team is going to walk you through a presentation that seeks to accomplish a few things. Walk you through and help you understand the claims handling and processing process. They will then detail to you the legal prompt payment standards in current law, and then we will share with you where things can go wrong in that system and the role that the insurance department can play in helping to resolve those issues. I think it's really important that at no time, and I appreciate the fact that this has been a long-going discussion in the state, it is not helpful to try to view this situation through the paradigm of good guys and bad guys. I think what we need to focus our full attention on is how to resolve these, as I said, and will repeat again, incredibly complex issues. What is mission critical is getting all to focus their entire attention on fixing the issues. And so to help you better understand how we can do that, I will turn the presentation over to Alex and Michelle.
Hello again. My name is Michelle Heaton. I'm the Health Law and Policy Legal Counsel. And we don't have the PowerPoint set up, but we'll flip through the pages together. So I'll try to tell you exactly where I am in it. So as DJ said, we want to just go over the life cycle of a claim, what goes into filing it and the complexities of that, not just in filing it, but in processing it, and then going through an overview of what the New Hampshire Insurance Department does. So if you turn to slide number 2, the background. Again, the purpose of this presentation is to explain the requirements of New Hampshire's prop pay law and the complexities of the health insurance claim process. This information is specific to the commercial insurance market for major medical insurance. It is not applicable to self-funded plans, government plans, church plans, Medicare, Medicaid, CHIP, or TRICARE. So that's very important to keep in mind. And this is really being provided as an overview for informational purposes. It's not going to address every hiccup that can happen in the processing of a claim. So if you turn to the next slide, number 3, the life cycle of a clean claim. This is a little bit of a visual to show you exactly what goes into processing a claim. First, you need to have a covered person who receives care that from a provider, usually that's an in-network. That provider collects information, has to fill out a claim form, submit that claim form within a certain amount of time, and then it gets to the health carrier. And the health carrier processes that claim in accordance with the benefits of the covered person's plan. And for electronic claims, this is supposed to be done within 15 days. For paper claims, they have 30 days to complete this process. If you turn to the next slide, number 4. Billing for care. So before we can even process a claim or submit a claim, there has to be care that's provided to a covered person in accordance with that person's insurance policy for covered benefits. This will typically require them to go to an in-network or preferred provider and receive medically necessary care. Sometimes that will also require prior authorization, or they may need a referral from their primary care provider before they can even receive the care. The provider also needs to collect the covered person's most up-to-date insurance information. People will frequently change insurance carriers, lose coverage, gain coverage, and if there's no coverage on the day of the services, then there can be no payment for those services. So it's very important to have the most up-to-date insurance information. And then claims need to be submitted within 90 days and include all necessary information. That means proper billing codes, relevant modifiers, proper diagnosis codes, and correct provider information, including the provider's address and MPI number. So if you turn to the next slide, number 5, this is a copy of a paper claim form. It's a standardized form, so it's the same every time you submit it, and it has a lot of basic information. The top part is, which you can't hardly see, because it's a little tiny, is the patient information. And then the bottom half is where you would put in the treatment codes, diagnosis codes, and modifiers if they apply, and all that information. And it seems like it should be a very straightforward process, but just to give you some visuals, these 2 manuals are for HCPCS and CPT codes. These are full of codes that could possibly be billed. So there's a code almost for everything. And like we were talking about earlier, we're always coming up with new codes for new services. And this is the ICD manual. This is specific to diagnoses, and the diagnoses have to line up properly with the services in the CPT codes and the HCPCS codes. So it gets very complex, and you really need to know what you're doing in order to fill out these forms. If the right code is not used with the right diagnosis code, it's not going to be covered. So that's part of the I wouldn't say problem, but that's part of the process, is making sure you're using the codes properly. They also need to be used in accordance with the contract. So the provider, we're talking about in-network providers here, has a contract with the carrier, and there's certain ways that they need to bill things. Sometimes there needs to be modifiers, sometimes there are bundled services or unbundled, so they have to be billed in accordance with the contract as well. So this is all just to get the claim to the carrier.
Sure,
So-
we have a question here.
Yeah, and so the person filling out the claim form, is she or he a coder, a medical, what do they call them?
It would depend on the practice, but yeah, there's a lot of medical billers who specialize in how to use these codes appropriately, depending on the practice size. It could be, someone that's working in the front office of a smaller practice.
Yeah.
And if it's a hospital, you probably have more sophisticated.
Right.
And again, the number of codes depends on the type of practice. If you're a mental health provider, for example, you're only probably dealing with a handful of codes, whereas if you're a hospital, you're dealing with a wide variety of codes and possible diagnoses.
So if the code is not a proper code, then that's when things go awry. And
Yes, and we're going to get to that next.
thanks.
So that's everything that goes into just being able to submit the code. So what we're going to talk about next is, I'm on slide 6 here, the prompt pay law and what exactly is included in it, claim denials and adverse determinations, the appeals process, and external review. So turning now to slide 7, prompt pay law, which is RSA 420J 8-A, and this is our prompt pay law that sets out certain time periods. What's important to note about prompt pay law is that it doesn't necessarily guarantee payment. What it's really talking about is that the claim is going to be processed within 15 days if it's electronic, or 30 days if it's a paper claim. And in order for it to be processed, it has to be a clean claim. So a clean claim definition is there in paragraph 2. And we're talking about it includes all the most current procedural codes, all the required fields. They're filled out correctly and completely so that the carrier can easily process the claim. Now, if it is a clean claim, everything's filled out, but there's additional information that's needed, then the carrier can request that additional information, the clock stops, and once they receive that additional information, the carrier now has 45 days to adjudicate the claim. So moving on to our next slide, number 8. Also included in our prompt pay law is an enforcement provision. And this is specific to prompt pay, and it's a little bit different than our general enforcement provisions, but it's important to highlight it because the enforcement for prompt pay comes into play when the commissioner has determined or established a pattern of overdue payments. And now the statute doesn't define a pattern of overdue payments, but we follow the market conduct regulation handbook, which is this pile here, that's put out by the NEIC, and it sets standards for how to do market conduct examinations and analysis. And it's fairly uniform across the country, but each state has its own specific laws that may require some tweaking. But generally, according to the Market Regulation Handbook, a 7% error rate is an established benchmark for claim practices. That means if in the midst of an examination we find that there's an error rate of greater than 7%, then it's presumed that the claims are not being handled in accordance with law. If it's less than 7%, then it's presumed that there's substantial compliance. So that's important to keep in mind. We're not expecting, and it would be somewhat unrealistic to expect that 100% of claims are handled correctly all the time. That would be the perfect utopian world. So moving on to slide 9, which is our MCAS data. MCAS is Market Conduct Annual Statement. That's what it stands for. And this is data that's collected by the NEIC on a national level, but all our state carriers participate in it. And it's a large data call of all different kinds of information. This is just a little bit of a snapshot of some of the information that we got out of it. And we use this as part of our market analysis that we'll get to a little bit later, but it gives a snapshot of how New Hampshire compares to the rest of the country. So according to this data, out of all the claims being filed, excluding pharmacy, we have a denial rate of 14.7%, which is less than the national average. If we're looking at claims submitted by in-network providers, again excluding pharmacy, 96.25% are for in-network providers and 3.75% are for out-of-network providers. And that's important because if you're an in-network provider, you already have a contract established with the carrier, and it's a lot easier to have your claims processed. If you're out-of-network, there's a lot more variables at play, so that can lead to delays in processing the claims. So of all the in-network claims that were submitted, about 96.9% are paid within 30 days. Now, this does not translate to prompt pay because our time periods are a little bit different. 30 days is more of a national benchmark, but it does tell us that a very large number are being paid within that 96. Of the ones being paid, 96.9% are being paid within 30 days. So that's a fairly quick turnaround. Then of the in-network claims that are denied, those are being processed at a rate of 91.7% within 30 days. So those two numbers give us a snapshot to show that the claims are being adjudicated fairly quickly, and most of them are being adjudicated for in-network claims, excluding pharmacy, within that 30 days. So if you turn to the next slide, number 10, we're going to start talking about claim denials a little. So to just give you some context, in the commercial market for calendar year 2022, there were approximately 16.3 million claims submitted. So it's a very large number. According to our CHIS data, there's a denial rate of about 10.3%. And I wouldn't compare this to the MCAS data because we're kind of talking about different things here, but they're somewhat in line. So on this slide here, on 10, there's a list according to our CHIS data of some of the top reasons why claims are denied. So we have an exact duplicate claim, information was requested and not provided or is incomplete, and you can see the list and the percentage of claims that are denied based on that reason. I also want to draw your attention to the very bottom where we're saying medical necessity. This is not one of the top claims, but it's worth putting on there because that's one of the reasons you're going to hear more often. And according to our CHIS data, it's only 0.65% of claims are being denied for that medical necessity reason. So when the claim is denied for a lot of these reasons, it's just a matter of correcting the information on the claim, maybe submitting more information, and then the claim can be resubmitted and processed, assuming that they now have all the correct information. If it can't be reprocessed because it's something like medical necessity, that's where we get into the appeals and external review process. So if you turn to the next slide on number 11,
Mr.
medical
Chairman,
necessity.
excuse me.
Yep.
Go ahead.
Could I just interrupt you at this point? Thank you. This is all very helpful. Could you just tell us a little bit more about what the definition of medical necessity is and who decides on what basis?
The next slide.
It is going to tell us
Yes, it is.
what a medical necessity is? Okay,
Yep. So
We got to define it.
great.
So in 420J3 are our definitions that are managed care, and XXV-B is medical necessity. And it means the healthcare services or products provided to an enrollee for the purposes of preventing, stabilizing, diagnosing, or treating an illness, injury, or disease, or the symptoms of an illness, injury, or disease in a manner that is consistent with generally accepted standards of medical practice, is clinically appropriate in terms of type, frequency, extent, site, and duration, and demonstrated through scientific evidence to be effective in improving health outcomes. Representative of best practice in the medical profession, and not primarily for the convenience of the enrollee or physician or other healthcare provider. So that is the definition that we apply throughout all of our regulations. This is the definition of medical necessity.
So now I do have a question. This is what I get for not looking ahead. That's why. Thank you. Now, it used to bug me that people would read 5 pages ahead and it couldn't stay with the presentation. Okay. So who decides what constitutes generally accepted standards of medical practice? Who defines what is generally accepted? It seems like you drive a truck through that.
Yes, so there's, generally speaking, the way the system is set up, the carrier comes up with medical guidelines for the treatment of whatever we're talking about. That needs to be based on scientific evidence, so peer-reviewed articles, research, what's happening in that field. So that would be put into the clinical guidelines. Now, if there is a dispute down the line, which is where we're going to go next, as to, is that the most up-to-date literature? Should you be considering something else? What about this study? Then you can go through the appeals and external review process, and we'll get to that next. So generally speaking, a plan is only going to reimburse items and services that are medically necessary, and that's pretty much the cornerstone of managed care. is that you're only, and insurance is that you're only going to get reimbursed for things that are medically necessary and also a covered benefit. So those are,
And I would just say, over the years, we have revisited this statute. Yeah.
So when you get a claim denied as medically unnecessary, somebody's pushing the envelope here, but they already know that it's medically unnecessary. Do you understand what I mean by
yeah,
pushing the
and
envelope?
it really depends on the circumstances.
But would it be included in the circumstances as one example?
It could be that, yeah, generally experimental stuff is excluded because it's not accepted that that is going to address the issue. So that's a little bit different, but yeah, if you're talking about an in-network provider, they should be up to speed on what is medically necessary or not. And if there's a disagreement on that, that's where we go through the appeals and external review process.
So what I'm trying to get at here, Mr. Chairman, is if it's known what's medically acceptable, then why would somebody put in a claim for something that's medically unnecessary unless they're attempting to rattle the cage?
Yeah, but
Is that it?
medically unnecessary was very low, right? Wasn't that a low number?
Well,
Yeah.
it is, but
It
still.
could
Yeah,
be.
so no, it's very rarely that happens. Well, let me tell you what I know. Okay. Each health insurance entity has a medical director.
Yep.
Okay, and the medical director's responsibility is to know what the standards of practice, the protocols, then know what is expected. Now, one of the things we used to joke about in the committee is we used to call it the cookbook, because you would say, okay, for the first time you do this, and then if that didn't work, then you do this, and then you do this. You keep turning the page, the cookbook. But that at the end of the day, everything is in terms of the standard of practice this is what everybody has agreed is the appropriate next step. But that can change. And then you take the example of the DSM, which is the mental health. I mean, that we're up to like 14 now. And when I first got started, we were like 4, right? And so, so yes, these
DSM
things do
5.
change.
Well, I understand that this is a dynamic process because we don't have settled science on everything. To
Well, you're
use a
learning. You're
phrase that
always
has
learning,
become
right.
quite popular these days.
That's why we call it
But
practicing
with
medicine,
respect
not
to
mastering it.
medically necessary, is this where Commissioner Betancourt's remarks with respect to people making mistakes? Why would
It
you
could be.
why would you put in a claim that you otherwise know is not medically necessary, and it therefore becomes part of the 0.65%?
So, I mean, again, there is a whole spectrum of reasons why medical necessity can go awry, but one of them could be that, to treat condition A, there are, these different treatments available. And the one that you did, is the most appropriate if the patient exhibits with, these 3 symptoms. And it could be in this instance, the treatment was provided, but for this patient, they only had 2 of those symptoms and not all 3. So it maybe wasn't the best. So it could be, things like that. There's different criteria that, a patient would have to meet for a certain condition. And it could be that, the provider's not as up to speed on some of those things. And the clinical guidelines can vary by carrier as well.
So in the instance, if I may, so in the case that you've just cited, the example you just cited, this is an adverse consequence.
Yes, it's an adverse determination.
Well, it's an adverse consequence as well for the insured because the provider made a mistake by not choosing the appropriate, best accepted course of care.
Yes, and in that instance, typically the patient is held harmless and the provider has to eat the cost of it.
Who decides that?
That's part of in provider contracts.
Thank you. I could go on. Thank you.
Why
Let's
don't
go
we
on to
move
let's
on, and
go
I
on to
think
my
it'll
next
answer
bill.
some more questions.
The next piece of legislation I passed.
So if we move on to 12 appeals. So if you have an adverse determination and your claim is denied, there is, carriers are required to have grievance procedures that are appeals processes. And if you look at 420J5, there's a list of things that it has to include, including timeframes, who's going to be reviewing it. And one of the things is the claimant can submit written comments, documents, records, and other information. And all the information and documents submitted would be reviewed by someone who's different than who made the initial denial. So there's a lot of protections in there. If that still does not resolve the issue, then if we turn to slide 13, you can go to external review. So the internal appeals process is handled at the carrier level, and even though there's different people, they all are within that carrier system. External review is going to an independent third party, and the sides submit their both of their arguments about why something is medically necessary or not, and then this independent review organization makes that determination. This is binding on the parties, and there's a lot of statutory requirements for how the system works as well. So if you looked at 420J5-A through 420J5-E, there's a lot of procedures, timeframes that need to be complied with. And if it's something that needs an expedient decision, there's like a 72-hour time frame for submitting these and getting a response.
And our experience, recent experience with this process is that about 40% of the time the carrier's decision gets overturned. So it's a meaningful process.
Yeah, and for calendar year 22, there were 46 eligible claims submitted for external review, and the department handles that submission process. So if you turn to the next slide, number 14, sometimes claims are adjudicated not as expected. And this kind of falls out of the realm of prompt pay because the claim is processed, so it's not a violation of prompt pay, but the amount of payment the provider may get may not be what they were expecting. And it could be that, you know, they're looking at the wrong fee schedule or miscalculated and thought they were supposed to get more money when in fact they're not necessarily entitled to it. Or it could be that the carriers processing it using the wrong fee schedule and are supposed to be paying more money. It could be that there are system configuration issues that lead to, you know, wrong fee schedule, wrong amount of co-insurance, or applying a co-insurance instead of co-payment. There's a variety of reasons why things can go wrong. And even though the claim is processed and there's no dispute this is a covered benefit, there is some discrepancy in the numbers and what is actually getting paid and what's not. So there's a lot of issues in that unless you go in and do a claims examination, you're looking at each one of these individual claims, there's no easy way to figure out what exactly went wrong here. So that kind of brings us to the role of the insurance department, which is slide 15.
Mr. Chairman, question?
Yes.
So are we still within 30 days here, or are we on a different clock when we
So-
move from page 12 to 13 to 14 here in the appeals process?
There are different timelines
So, right.
associated with appeals and grievances, and then again with external review.
So where are we now? What kind of a clock applies in the appeals process?
Part of it depends on when the covered person submits the appeal. So I believe they have 180 days to submit the appeal. And then assuming, you know, they have all the right information, I believe they have 30 days to adjudicate it, but I might have to double
But no,
check that.
but if it was a clean claim, so it just, and then by the time the check gets cut, that's going to be close. So that's not more than 30,
That's-
you know, the 30
So-
plus days. And then it's because it was adjudicated, but now the payment is made and the doctor says, oh, this is not what I was expecting.
Yes, and that
That
wouldn't
can
be a
happen in a
violation
very
of
short
prompt
period
pay.
of time.
Yes.
I'm still back on the clock if you don't mind. So 30 days, adverse decision. Now the provider is notified. Now we have 180 days. He or she, they have 180 days to appeal. If an appeal is filed anytime within the 180 days, then there's a new clock that starts on the appeal, and that's 30 days for a decision to
60,
be
I thought it was
rendered.
60.
I believe so, but I'd have to double check that. It's in the
Yeah, 'cause
statute.
I mean,
There's
all this is
statutory.
very critical because one of the issues that we're hearing is that these things go on and on and on forever. And it seems to me that there are definite timeframes here
Yes.
And we may not be entirely happy with what they are, but it's 30, 180, 30, yeah. So if you could
Yes.
just keep that in mind as you go along, I'd appreciate it. Because I'm trying to keep track of like worst case scenarios here where, okay, it went 30 days, I got notified. Well, the person filed 179 days later. Well, then it was another 30 days. Okay, thank you.
Yes, and a lot of time too, if more information is needed, those clocks stop. So it oftentimes becomes dependent on the person filing these appeals, filing the necessary information. You know, if they're filing it immediately, this whole process is going to move much quicker. But again, if they're waiting to 179th day to do it, then it's going to stretch out the process longer.
Okay, so in sports terms, if we might, this will be helpful to me. Basketball or football, we can actually have a timeout.
Yes. Yeah. So while the carrier is waiting for them to submit more information, once they say, oh, we can't do anything yet, we need you to submit this information.
So the clock stops until they get the additional information, and then the clock restarts.
Yes.
So now it could be even longer than 180 days.
Yes.
Okay, this is very helpful. Thank you. Okay.
Okay. So are we all set on those issues? Okay. So slide 15, the role of the insurance department. So the insurance department enforces the insurance laws to protect consumers and to ensure a stable market. And we do that with our consumer services, our market analysis, investigations, examinations. What the department does not have the jurisdiction or authority to do is to resolve contractual disputes between insurers and any entity or individual that they contract with. So it's important to keep in mind. We're regulating the market. We want to make sure things are moving in accordance with law, but part of this issue is contractual disputes between insurers and the entities they contract with, and we don't have jurisdiction over that. So moving on to the next slide, number 16. When we're talking about insurance regulation, we like to talk about the continuum of insurance regulation, and that's what this is trying to show you, is that the continuum gives regulators the flexibility to use the most appropriate amount of regulation necessary to address an issue. It gives us more flexibility to use our resources in the most efficient way possible to attain quick results. So not every issue is going to lead to a market conduct examination because those are very lengthy, time-consuming, resource-intensive processes. Sometimes it's a lot quicker and more effective for us to do light touch, which would be on the contact end of the spectrum, which means picking up the phone, making a phone call, sending a letter, something simple like that to resolve the issue. And so that's at one end of the spectrum. And then it works up to investigations, which can include documents requests, interrogatories, interviews, attempting to facilitate some type of dispute resolution between the parties. And then it goes towards examination. Examination is a very detailed, extensive process that we'll get to later. And then all of this can lead to enforcement. And on the far right side of enforcement is the most harsh thing we could do, which would be to revoke a license. And that would only be in the most extreme situations would we revoke a license. So if you turn to slide number 17, our consumer services unit is one of the tools we use, and they help educate consumers and residents about insurance products, assist residents and healthcare providers in navigating the complexity of the insurance industry, and assist other department staff in doing investigations. So for calendar year 22, the consumer services received 313 consumer complaints relating to health products. Of those, 73% related to some kind of claims issue. And of that 73%, only 20% of those complaints were confirmed as a regulatory violation. We also, our consumer services also helps healthcare providers, and we call their submissions inquiries as opposed to complaints, which are by consumers. And for calendar year 22, we received 115 healthcare provider inquiries. 81% of those related to some kind of claims issue, and then 25% of those were confirmed as a regulatory violation. And then we have our consumer services contact information there if anyone wants to reach out about their own specific complaint or have a constituent that you would like to direct our way. So next slide, number 18, we're on market analysis. Market analysis is another part of the continuum of regulation that consists of collecting and analyzing data and other information to assist regulators in monitoring the market, identifying problems early on, and focusing resources in a way to better prioritize and coordinate various market conduct functions. So if you turn to the next slide, number 19. Next on the continuum is investigations. So our investigation statute is RSA 400A16. This gives us very broad authority to investigate anything under Title 37, which is relating to insurance. For calendar year 22, our market conduct team had 45 open investigations relating to health insurance. Of those, 73% related to some kind of claims handling issue. Investigations are confidential and we can't disclose any of the information obtained during an investigation, and that's by statute. And we can disclose when we do take a regulatory action. So if you want to look at the department's website under legal information, if you scroll down towards the bottom, there's a listing of all recent regulatory actions that we have taken or hearings that are currently scheduled to take place soon. And finally, we're on slide 20. We have market conduct examinations. And again, this is the Market Conduct Regulation Handbook. It is a very thorough compilation of how to do a market conduct examination. We also have a statute, 400A37, that details the process, and that flow chart here kind of details the different stages of an examination. There's a lot of due process built in to make sure carriers have an opportunity to weigh in when there are findings, and it can lead to, there's an examination report, enforcement actions down the line, but it can be a very lengthy process because it's very detailed and very resource intensive. And those are privileged and confidential until regulatory action is taken as well. So while we may be in the midst of a market conduct examination, we are unable to disclose any of those details until there is a final regulatory action taken.
Phenomenal job, Michelle. And thank you, Alex, as well. Just a few brief concluding thoughts before we take any questions that you still may have. You know, obviously, I hope the presentation this afternoon has demonstrated the nature and complexity of the issue as I outlined at the outset. And my belief that, unfortunately, I think getting to the bottom of this situation is well beyond the scope of legislation. And I know that that is perhaps disappointing. I used to sit in your seats. I completely understand the strong desire to be able to fix problems via piece of legislation. Unfortunately, I think the nature of this is outside of that scope. So what is the answer, at least in the short term? The answer is for the appropriate individuals and decision makers on both sides, both the carrier side and the provider side, to come together with the full complement of information in the claims file and work through those claims. And my understanding is that that process is currently well underway. That said, I appreciate the fact that that process is slow, and our hospitals in particular, I know, are frustrated. But as we sit here today, at least, that is the most effective way to resolve these issues and to get the providers appropriately paid. My commitment to you and our department's commitment to you will be to do everything that we can to facilitate those conversations, to provide resources and expertise wherever and whenever we can, and to hold the insurance carriers accountable. Those are the entities that we have regulatory authority over. That is part of our job. But as it pertains to the long-standing dispute, I have made a personal commitment to do everything that I can to resolve this issue. This issue was featured prominently last month when my hearing to be insurance commissioner took place before the Executive Council. And so that is a commitment that I made to them. It is a commitment that I will make to you as well. You know, I think, again, as you hear and see some of these reports about the current dynamic, I think that of the slides that we've provided you with, and I think the material here is incredibly useful to you, I think to understand what's going on here, it's not prompt pay. It is the issues that are highlighted here on the slide that says claim adjudicated not as expected. That is what we believe is at the core of the dispute. And so, again, we will work with both sides to figure out these issues. If there are glitches in the system, if there are systematic problems in the system, we will do everything we can to work with the parties to identify those issues too. I'll just conclude by saying that, I've been asked, and I know the previous commissioner was asked, why not bring forward a market conduct exam to this issue? From my perspective, the answer is fairly simple. My goal is to get the providers paid quickly. I am told, and they relay to me, and I'm sure they've relayed to you, that some of them are struggling financially and that these holdups are impacting their operations. I have absolutely no reason to not believe those claims are absolutely true. And so that being the case, the commitment, and I think the goal has to be to move as quickly as we can to resolve these issues and get them paid. And as I said, as grueling as that process is to sit down and make sure the claims are clean, to make sure that you've got the interplay between the allowed amount, the charged amount, and all of those different complexities that go into this thing, it's a grind, I will admit, but it is faster than this. So at least for now, my goal is to try to not take the easy way out, but to try to do the thing that is going to be most quick. That's not to say that we wouldn't do an exam. It's an important tool that we have as regulators. I would never take important tools off the table for us. So it's not to say that we wouldn't at some point. I am a patient man, a fair man. My kids might dispute that some days, but I try. I want to see continued progress, and I want to see that we are on a trajectory to end this issue. And that is going to be my focus and goal. Thank you.
Any questions?
So how we, when clearly there's some cases that just are going on too long, how do we create a system where it forces a conversation about what's going on, why? I mean, there must be some kind of drop dead date, or something that say, boy, we need to get the parties in the room together and figure out why this is not paid. I mean, I don't know if it's a dollar amount or a time frame amount or something, but it seems to me that there has to be some way to when a case has just been hanging around way too long or just not been paid, there's got to be some way we can, have the department intervene and say, okay, let's get this taken care of.
So, as I said, we don't have jurisdiction over contractual disputes between providers and carriers. That being said, the department is a resource available. We have in the past, and we continue to do so, help to try to mediate disputes and get some common ground. From those experiences, it's not that there is one issue that just needs to be fixed. It's not that, these claims are not being processed because of this one thing. It's a variety of issues. And a lot of the time, it's that the providers and the carriers are, in a way, talking a different language, and they really do need to just get in the same room and work through these things. And, they do have civil remedies available because this is a contractual dispute between the two parties.
Mr. Chairman.
You're telling the physician should sue the insurance company?
I think that's a last resort. I think they'll be able to work out their difficulties.
Yes.
And with reference to your not being able to intervene in terms of contractual disputes, nevertheless, from your vantage point, are you seeing any patterns that are examples of what might be considered good faith or suspicious in nature with respect to delays? And I'm thinking once again about, especially with respect to the clock questions that I posed. The clock can stop at some point during the 180 days for information. I could see that hypothetically as a stalling tactic if I wanted to take a kind of a dark view of all of this. But I'm just not being as involved as you all are. I'm just wondering, are there any points at which you are seeing things that even though you do not have the tools to be able to effectuate what the chairman is asking to get things moved along more expeditiously, are you seeing any patterns of behavior that are suspect and disturbing?
I have not seen any patterns along the lines of what you described, and if I was, I would assure you that they would be getting a knock at the door from our enforcement unit. As I said at the beginning, what I see here are people who are trying as best as they can in good faith to work through an incredibly complex system. I'll give you an example. Michelle, myself, Jason Dexter, we personally sat in on, I guess for lack of a better term, you could call a mediation session between a carrier and New Hampshire Hospital. We felt as though we had a special obligation to New Hampshire Hospital, being that they are a state entity, and given the nature of the work that they do. And to sit down and go through claim by claim and understand the little ways in which these things can go sideways. To Michelle's point, sometimes the communications breakdowns that happen, where one person is referring to this thing, the other person misinterprets what that thing is, and then sometimes there are just outright staffing issues. I mean, I think we all appreciate that across the state. There's turnover, there's staffing challenges that all come together, along with the complexity of the issues that we've talked about, to cause delays. And sometimes it's a matter of, hey, we sent you an email several months ago saying that the only thing that we needed to properly adjudicate this claim was an explanation of benefits. And you say, okay, well, where did that email go to? Well, it went to Susan Jones. Well, Susan Jones left 3 weeks ago. So we've got to go through that whole process all over again. As I said, it's a damnable misery. It really is. And there are no easy solutions here. And I appreciate the frustrations. I appreciate the pressure that the hospitals and the other providers are facing. But I can't come here and always give you good news. I can give you the truth, which is what I will always try to do. And the truth is that the way we continue to make some progress with this is to go through this slow and, yes, long and arduous process. But it is going to be the thing that will ultimately iron out the issues. And then, as Michelle said, as we go through this process, if we are starting to identify systematic issues, then it opens up another series of potential tools that we can bring to the table.
So, Mr. Chairman, so it's interesting you use the word systematic, or because I was thinking about if you're not finding human issues that are troubling, so we're not talking about mistakes. This went to Susan Jones. She's not here anymore. Whatever. So, are you, as you look at the system, do you believe that the system is a good system and that it doesn't really need tweaking, fixing, or overhaul? It's not the system that is the problem. It's that we have people involved. And the people who are feeling this, of course, are most that we're hearing from are the small providers and the patients, the policyholders. But it's not a system problem. It's the complexity that's the issue, but not the way in which the system is working. It's the complexity within the system.
I think the answer to that is it can sometimes be both. I mean, it is consistent that the system is complex. And yes, it disproportionately causes headaches for the smaller providers who don't have big back office staffs, individuals with years of experience on how to properly bill and how to properly handle these things. Yeah, that complexity is and will always be a real challenge for them. Is there an opportunity to simplify this system? I'm sure that there is. That being said, no system is ever going to be perfect, and humans are not perfect. So it's not an absolute. In terms of the system, though, because you raised
but so I just want to stop you at the point where You said, can the system be simplified? I'm sure it can be. Could you elaborate on that?
Yeah, that
please?
would have to be a negotiation between the carrier and the provider as to how
But you
they
must
want
have
this to
something
go.
in mind here when you say that.
It's well beyond my scope.
No, you're saying you believe that it can be simplified.
Sure, I'm an eternal optimist. I got to believe
Oh,
there's
okay.
a better
So-
way than what we're looking
So
at
it's
here.
rooted in optimism
Yeah.
based on the fact that there are problems, but you don't have any model in mind here that would be a simpler model.
No, not as I sit here today.
All right, so I'm getting your optimism. Thanks.
You're getting my optimism. I'll
Okay.
give. It's one of the many services I provide, Representative Terry.
Yes.
But to further elaborate on your point, though, there are times when the system itself will have an issue, and I'll give you a prominent example. The state's largest carrier, about 2 years ago now, went through a systems migration. In the process of that systems migration, as is the case in most circumstances by which you have large systems migrations, things didn't go as smoothly as was hoped. And so that did create a problem. Now, that problem was identified. They're working to remedy the problem. To my knowledge, what has been represented to me is that the most glaring issues of that migration have been addressed, but of course there is some residual issues from that still have to be resolved. So there are times when the system itself can break down and not just be the human aspect to that.
I would, not to split hairs here, but I wouldn't consider that so much the system as the procedures that are utilized within the system, because you just identified, that a change in the way in which the provider was handling these claims. We're talking about software, computer software, probably. So it's not the process, it's the tools and the mechanisms.
Sure.
That can create greater problems.
Right.
Yes. Okay.
The distinction that I was simply trying to make there was during that period of time, during that difficult transition, the billing folks could have done everything exactly as they were supposed to have done it, and it was still going to be kicked out.
Okay, great. Before we take action, I do want to give the sponsor an opportunity to explain where they're coming from. So, yeah. Well, excuse me. The sponsoring association is the hospital association.
I know, you just promoted me. I
Yeah,
thought it was
I
very
know.
nice of
See,
you.
now that you're retired, maybe you want to run for the state house.
I'm not qualified. So thank you. For the record, Paula Minahan, Senior Vice President, State Government Relations for the New Hampshire Hospital Association. We did ask Senator Susie to sponsor this bill, and I appreciate you giving me the opportunity to speak for a couple minutes. And I appreciate very much all the work that went into this presentation, and this was, I thought, really, really well done. I think, and I won't quote anyone that spoke because there were a lot of people that spoke, but it is a very complex system. And that's why prompt pay, I would say, back in, I'm trying to remember, I was a representative when this passed, probably back in 2009, when prompt pay passed. What we have found and why we asked this bill to be introduced was because there, as laws, as you know, after a while, sometimes we need to amend laws. And that is why we were trying to address, and I'm not going to get into specifics about any carrier, but we put this in for, because our hospitals, have to bill many, many carriers. And the problem is, and I think Representative Terry was kind of getting to this, when the clock stops, and the clock sort of stops, that's kind of the problem, that the bill, the claim is pended or denied. But when it's pended, then you're asking for additional information, and then nothing happens. So that isn't a clean claim. It's just sits there. It's in their system. It's a pended claim. So this
we were attempting to do is to kind of close that, make the clock start ticking again, because it's not ticking. So the part that we added was, or to adjudicate the claim within 45 calendar days of receipt of additional information. And then current law is the claim shall be treated as a clean claim. We added that clock start ticking again because it's not ticking. That's the problem. One of the problems. The systems are very complex, but they don't fall within the clean claim definition. So that's what is the problem, because according to the carriers. What else did I? So yeah, pended. I think these statistics are interesting, but another interesting statistic would be to look at the overturn rate of the denials, because we understand that that is just administratively just adds so much complexity to the system. When you deny, you appeal, as Michelle very accurately explained how, again, another clock starts ticking. But if you're ultimately going to pay the claim, that would be a very interesting statistic, because that's just a lot of work to ultimately get the claim paid. And I think her statistic on external review is interesting too, because that one was to go to external review, that's pretty intense. And for 46 claims, 40% of those were overturned. So I think that's a really interesting statistic as well. But to get back to the bill, which I'm not sure, I mean, of course, we would like you to pass this bill. We believe there is a need because, again, we're trying to address when they're just sitting there. So that's what we were attempting to do with this bill. But I'm not at liberty, or I don't think it's appropriate to get into specifics about any particular process going on between hospitals and carriers. But in general, that is what we always encourage, is that they sit down and work through issue by issue. I would contend, and I think some of you know, but I worked for an insurance carrier. I was provider relations director for 14 years. So what I would always tell people is to go out and meet with the provider and then let us know if there are systemic issues. I would contend sometimes there are systemic issues. And we, as has been indicated by the commissioner, when you go through a system upgrade, which hospitals do, EMRs, electronic medical record, when they go through those system upgrades, there are glitches, but we've been dealing with some glitches with some carriers for over 2 years. So that is a long time. So I would contend that there are still system issues, and going through claim by claim, while it's helpful, what really should be happening is figuring out the system issues that are the trends that are coming out of every single claim that you're reviewing, because that is very time consuming for everyone. So I think that's all I had. I'm happy to answer any questions if I can.
So, with respect to my earlier questions and following up on your remarks, there are issues once I understand a claim does not become a clean claim when there's a problem.
Right.
So a claim can go into pending status, where presumably more information is being requested for
Right.
whatever reasons.
Correct.
But there is no clock like there is in basketball. You only get 1 minute for a timeout, and then everybody's got to go back out there and play again. There is no such clock when a claim goes into pending. It could be in there. It could be pending indefinitely. Is that the issue you're identifying, and you want a time frame assigned to pending?
Thank you for your question. So when I think Michelle correctly identified, when it's pended and you request additional information, the clock stops there for the carrier, because they're waiting for the provider, unless there's something in the contract. I'm not privy to those contracts, so I wouldn't know. But what I'm saying is what we have been told by our hospitals, once the information is requested, it's all I mean, there are human beings working on the computers, but it's all electronic, of course. So they see what is requested. Did they forget to provide a medical record? Did they need a lab test, results, something, whatever it is? They send that. And then what doesn't happen is nothing happens on the other end. So there is no clock. So that's why we added the words that we did to make sure that after 45 days, once you get the additional information, once you do something to the claim, process it. And if you don't process it, then pay it as a clean claim.
So what you're doing is you're adding specificity in terms of what must be done within a certain time frame once certain information is received.
Yes.
Whereas now, there is no specificity, there is no time clock. It could just stay there forever. I've heard that it's not intentional. There's no evidence of intentionality, but let's just call it benign neglect or, human error. But what you want to do is tighten this up and say, once the information is received, you have 45 days to
act
make a
on it.
determination, and then it goes to the next step, and then we got another clock going on.
Yes. So do something with it. And if it's whatever happens, and like you said, if there's more action that's needed, then that you go to the next step. Yep.
Okay.
Thank you.
All right. So what do you guys want to do with this bill?
Interim study. For 2 weeks.
Right. Well, I mean, the problem I would have to say, Paula, is that it's when you say just pay it. Okay. Well, what happens if it wasn't going to get paid? I mean, what happens if there were?
And they'll know within a certain period of time.
Isn't it about a time period? It's not about a decision. It's not about a specific.
No, the bill says pay it. Pay it.
If it's
Or
not,
let us
After
know.
a certain point in time, just pay it.
it must be paid regardless.
That's the way I read it.
Would that be correct?
Okay. Yeah.
So I'm not sure that this proposed language is necessary because under the law, it already says that upon the health carrier's receipt of a requested information, the health carrier shall adjudicate the claim within 45 calendar days. So there is already a time period built in there. But again, we're saying adjudicate the claim. I'm not exactly sure what the exact language of this bill says, but it would either be you pay it because it's covered or you deny it.
Yeah, it says pay it. It says pay it as though it was a clean claim, right? Isn't that what it says, Paula? I'm gonna go get it, but yeah, you could both sit there.
It does say that, but it's not happening. So so then treat it as sort of like, because it says if current law, if the required notice is not provided, so if the payer did not send the notice, then the claim shall be treated as a clean claim. So what we added was, it looks like we added that entire bolded, but we didn't. So we added or to adjudicate the claim within 40, if they don't do that sentence above, ahead, if they don't do it, then you have to pay it as a clean claim. You're right, but we're just saying process it.
So that's the teeth? In other words, if you don't do this within 45 days, then you must pay it as a clean claim.
Yeah, no,
So
you're
there's
right.
the penalty.
You're right.
Okay.
That's one way
So,
to.
because the language is already that it has to be done within 45 days, but it doesn't say what happens if you don't do it within 45 days. And you're saying,
Right.
well, because the law doesn't say what has to be done after 45 days. If 45 days expires, this is what will have to happen. This would be the consequence after 45 days
That's-
if they don't do what they're supposed to do.
That's
within a
good
time
way.
frame.
That's a good way to
Is this
describe it.
just boiling it down
Yeah.
so that we can all understand this? Okay. Okay. And so now the question is, so what do we want to do with this?
Is that true?
Is that true? Is that true?
So if you don't pay or adjudicate the claim within the time period and it does get covered, there is an interest penalty. So you would have to pay that additional interest. So if it took you 60 days to adjudicate, and you had to request additional information, you would have to pay that interest for that additional 15 days.
Do
So
you
there-
get involved after 45 days as a
Not
department?
necessarily, because then it goes back to, in the midst of a claims exam, if that 7%, if 7% are handled,
Right.
if the error rate is less than 7%, the presumption is that they're being handled appropriately. If it's greater than 7%, then there's a presumption that they're not being handled in accordance with law. So we never presume that there's 100% compliance, but that's why that interest is built in. So if they're unable to adjudicate that claim within the time period, they do have to pay interest as well.
Well, who decides when the interest and the payment have to be made?
If it's past that time, the carrier should be adding that interest in. And
Okay.
it's my understanding they usually
But-
do. In the context of an examination, we would go in and say, if this was not paid within that time frame, was interest paid as well? And that would be one of the things we would be looking at in an examination.
So if
or
I
an
didn't want to,
investigation.
so if I didn't want to pay this, and in 45 days expired, now I have a certain rate of interest. What is it, market rate? I mean,
I would have to.
anyway, so now we have interest that is being added onto the claim. But now why would I pay it? I mean, hypothetically, this could go on forever.
And this is where market regulation comes.
Who's
So
going to
this
make
is-
somebody do something?
The department would step in those types of cases. And if this situation were to come up, we would hope that the provider would file an inquiry with the department in our consumer services. We would take a look at it and we would, probably tell the carrier, why aren't you paying?
So effectively
Is
what?
there a problem here,
So the department gets involved here and basically leans on them. That's
Yes,
what
that's
happens.
one
You-
of the
you
tools
can't
in our
make
regulatory
them, You
handbook.
can't make them pay, but if they continue to resist paying and the interest charges are going up, like, the meter on the taxi, you can lean on them. And in other words, it doesn't look good for them if they don't eventually process this.
Yes, and just to clarify, we cannot require payment.
Right,
But we can, if they are not following the law, we can sanction them for not following the law.
And so you might be looking for a way in which they're not following the law, because other than would not following the law mean that they didn't act in good faith within the 45 days?
Yes, if they
And you
were
could make that
acting-
determination?
Yes, if they're acting in bad faith.
So you already have this tool,
Yes,
so we don't really need this bill.
not
Do you take a
really.
position? Or do you take a position on this?
I don't believe we have. No, we have
Is
not.
it because you haven't taken a position, or that you don't choose to take a position?
I was not around when this was
Don't
introduced,
ask
so I don't
her.
know.
She's only this is only her first year on the job. Right? How many?
No, I've been here for 4 years. I was on maternity
Oh,
leave in the last.
Oh,
session.
okay, okay.
Concerns with the way it was drafted and these issues that have come out.
Okay. Well,
Okay.
here's the question: if
Here we go.
If I follow this conversation, that theoretically, at the end of the day, that their interest is paid, and that's theoretically the penalty. But it is clearly the insurance company is violating the statute. Okay, and the issue then is at that point is that when there's a violation of a statute, that we have the draconian opportunity for the department to pull their license for doing business because they keep systematically violating a statute. So maybe what we should do is have some kind of and I guess the way to do this right, it would be the provider, because in this case they're the constituent who's being harmed by these insurance companies, that the providers should notify the department of this violation. And
Yeah,
so
yeah.
at that point, you will now can start your collecting information about how often this insurance company is violating that default.
Yeah, we do that. And actually, at a certain point, we took on that responsibility of separately taking complaints from healthcare providers.
Okay. So, but so Paula, if if we put into the statute that sorry, we only have one mic. Maybe we can have you guys opposite mics here, but maybe we should have that the provider would have a form to notify the department that here we go again.
Well,
we got
we-
another one where they
Why
haven't
do we-
paid on a timely
Yeah,
fashion.
Mr. Chairman, why do we need a law? They can just issue a bulletin.
This is not a bulletin material.
It's not bulletin
This
material.
is not
No,
bulletin
we do appreciate that the department has now started collecting provider concerns, and there is, I think they're seeing more of interaction. It's always been consumers, and I think it was kind of I'm not going to say it was assumed, but of course providers are consumers too. But it was really, we always interpreted it was really more a patient complaint.
Right.
So now I think they've made it very explicit. It's right on their website. So I think that is very helpful. And that may be another route that I believe that is a route that the providers are
Right.
utilizing. I was trying to text a colleague to find out. I have not back in the day, many years ago when I was doing a different job at the association. My understanding, and I don't know if this is still the case, it's not an automatic. That interest penalty does not automatically get applied to a paid claim. The provider would have to basically submit a bill, if you will. That has been at least some of the experience our members have had, but I do not know that is actually what happens now. I'm trying to find out, but it doesn't automatically happen necessarily.
Okay, but you guys think it does, right? You think that that interest is supposed to be paid right away?
Well, the law requires that it automatically be added in. But I think what Paul is saying is that doesn't always happen. And that is one of the things
that
we
the
look
insurance
for.
company says, well, that's nice. Well, where's the bill, right?
Yeah.
The interest.
And when we do these deep dive, market conduct exam, looking at claims, that's one of the things we look at was interest paid after 45 days.
Okay. All right. So here's where I'm thinking. Yeah, right.
Who calculates the 7%?
Exactly. How
Is it
does this paperwork work?
Who-
So the insurance anthem, you guys always pay that interest on time? Why don't you come over here, and take one of these mics here? Come on down.
Here.
Yes,
Sabrina
you do. Yes, you
Dunlap
need to come up here. Yes.
from
Good.
Anthem. I talked to our legal counsel earlier and was verifying that interest actually, we have a system it automatically attaches. And I believe the same is true for Cigna and Harvard Pilgrim as well. So we have a great interest in paying claims on time. I just want to put that out there.
So the providers add in the 7% after 45 days if they haven't paid the claim.
On our end, it automatically,
You automatically begin, the clock begins.
our system automatically attaches the required interest.
Is that,
That gets paid
are you
to the
doing
provider.
that voluntarily or because
To follow the,
feel
to
you-
follow the
to
law.
follow well, the law is instructing you to do that? The department tells you have to do that?
I believe
The
that's
law does?
correct. If they
Okay.
aren't telling us, we are doing it, but I believe it's correct that we were being told that is how to make sure we follow the law.
Okay.
Does that
it's 1
interest get added to the minimum loss ratio? Is that considered a health cost?
That's
Well-
a good question.
Well, the reason I ask that is notwithstanding that hate to think this is the reason why our premiums are going up, but is this a way for us to be able to track how bad these payments are, whether these late payments problem is really occurring, is that if you have to know that the department, don't you guys need to know whether that money's where that interest is coming from, how that's billed and whether it's part of the minimum? Because if you don't know, then I would say it's being thrown in the minimum loss ratio, and that's outrageous. We don't want that. Okay. We will schedule this bill again. Okay. On November 7th. And I would like to hear a way in which instead of passing what I consider this draconian bill, which says just pay it as though it's a clean claim, that I would like to see a system in place or something, some proposed way we could track it, and so that you guys really do know how much of a problem it is out there, and that these things are not getting paid. And I say that I would look at where that money's coming, getting billed, and how it's getting billed, and how you guys see it, because I sure hope it's not going into my minimum loss ratio number, right?
I will look into that too. I'm fairly certain it does not. It is a penalty for the
So
carriers.
therefore, when that's reported to the department, as in terms of your loss, it's got to be segmented off, right? It's got to be, there must be some separation. I knew there was going to be a benefit of this minimum loss ratio. Okay, does everybody know what I'm talking about?
Yes.
Yeah.
Our financial analysis team does do consistent review of these issues and money matters, and they're constantly reviewing a lot of financial information every quarter. So I can follow up with them and find out exactly how penalties work into the medical loss ratio, but be assured that our financial team is on it. We are monitoring all the financials, and if we saw something concerning in the financials that were to indicate an improper business practice, that would be one of the things that could trigger a market conduct investigation or examination.
Okay, yes.
I just have a quick question. I guess I'd pose it to Paula. We're talking about these numbers and the penalties, et cetera, but aren't there people at the end of the day, people who don't get a claim, who are maybe in real serious financial hardship because a claim was denied?
I'm sorry, are we talking about the providers or?
Yeah, these are hospitals.
Or all providers?
Okay,
in
so the
general?
patient is
The
not.
patient is not.
Okay.
No,
okay,
patient's
so I
not
wanna-
No, as Michelle said, they're a contractual, well.
Okay.
It's a contract. So if you're an in-network provider, you cannot balance bill the patient.
Right.
So, thank you. If you would just reiterate or correct me on what I believe I heard a few minutes ago, the department has provided information or given information to providers that reminds them, shall we say, of their obligation to try to collect from the insurance company rather than to more quickly default to going after the patient. And did I hear you say?
No, they don't have
it's
anything to
happening
involve the
with
patient.
A greater frequency that the providers are trying to be more conscientious and aggressive about following up on claims that have been filed with the insurance carrier? Because we all know, as patients, there's that statement that we all sign without reading that says that ultimately we will pay if the provider doesn't pay. Excuse me, the insurance company doesn't pay. And it would seem to me that would be an easy out for a provider who says, I just don't want to be involved with this gigantic bureaucracy any longer. I'm just going to go after, and therefore, then it does come back on the policyholder and the patient, who
That-
now is billed for, maybe hundreds or thousands of dollars.
It's for that form that we sign is if it's a non-covered service. You can't bill, if you have a contractual relationship with the carrier, in that contractual relationship, in that contract, it does say that you will not balance bill the patient. So no, it's more for something that is not covered ultimately. If if the insurance is not, if there's not eligible or whatever, if the insurance ran out, if it was the wrong, whatever, or it's just not a covered service, that's what that is. Yeah.
Okay, so you guys will help us out so we can not have to pass this bill, but we need some way to, make sure you're being notified that if a carrier is has lapsed in getting these things done in a timely fashion. Great. Okay, with that, we're done. Not. No, we're going to meet again.
Do we have a recommendation as the
Interim study.
the full committee, or do we?
At this point, we're going to have another subcommittee on this bill.
We'll have another subcommittee on this bill.
On the 5th, on the 7th, 7th.
Okay, we'll take it up again on the 7th. Thank you.
Yeah. Okay? Well, what happened was,